This is the South African Broadcasting Corporation. Added case number 048
Okay, this is the court, my lady. I appear for the first and second applicants in this matter, together with my learned friend, Mr. Mwela. Sorry, my other learned friend, Ms. Ngabula, was unable to be here, but she was part of the preparation as well as this.
Thank you.
As your ladyship pleases, together with my learned friends, Mr. Saludazana and Jogwe, the respondents.
Thank you. My lady, just by way of housekeeping, just 2 items. My learned friend and I have had a discussion about the time.
Yes, I'm great. Thank you.
And roughly, we're going to take about 2 hours each. And depending on what time we finish, I might have the rest of 15 minutes. But that's, we've divided up when we stopped when and so on. And also on the basis that if I go over, then obviously it will affect my reply time. But we will appreciate.
You can take it that I've read the heads,
Yes.
and that I've read the papers.
Yes, of course. Thank you, my lady.
That should speed things along.
It will, yeah.
Yes.
No, it will assist us, my lady. And in fact, I want to start right there. My lady, oh yes, sorry, another housekeeping issue. We have, sure when I attend, but there's a case which I came across overnight, which is not part of our head of argument, and not even in the supplementary bundle. I beg leave to hand a copy up. It's the case of the Citizen versus McBride, constitutional court.
I assume that that Mr. Matau and his team have been given a copy.
Yes, we offered and they said we must give it them here. But it's a...
Thank you.
Thank you. Right.
Thank you.
So, my lady, by way of signposting and a general broad brush, I want firstly to say to your ladyship what ground I'm going to cover at a very broad level,
Yes.
without the specifics. I'll give this what I call the high-level pointers of what the case is about and what it is not about. Then I will deal with some of what I call the preliminary defenses that have been raised.
Yes.
And I'll do that very quickly. They don't merit a long time.
Yes.
And the third and important topic will be dealing with the issue of freedom of expression. And here we're going to be quite extensive because in our respectful submission, that is the only defense on the merits that has been raised by the SABC. And we will then demonstrate why it's unsustainable on these facts. Then we'll deal briefly with the nature of the remedies sought, but also that shouldn't take long. The court is familiar. And even cost.
Yes.
So that's the broad outline.
Thank you. Please go ahead.
Thank you. Now, starting with what I call the high-level pointers or signposting. I just want to say this up front, that this is a very, very important case in relation to, shall we say, where we are as a democracy. But more specifically in relation to the debate around freedom of expression, political rights, and so on. The leadership is fully aware these are matters that have been debated ad nauseum in our courts. But maybe the special flavor of this case is that we will be looking at freedom of expression from the point of view of the citizen. Normally, the majority of the cases is from the point of view of the media, newspapers, and so on. And I will dwell on that issue very, very much when I deal with what I call the third topic. But fortunately for your ladyship, for this very court, has pronounced on the importance of this matter, not least when it ordered that the matter should be referred to a special allocation, which is why we're here now. Specifically because of what your sister Yakub J said was the importance of the issues, which could not have been dealt with in the urgent court, and we're obliged with that view. Now, the other fortunate thing for your ladyship is that this court has also pronounced itself on what I would call the nub of the issues in this matter. And it did so in the case that we have put in our preamble, my lady, to our heads. That was the case of Freedom of Expression Institute versus the chair of the what is known as the CCC, the Complaints and Compliance Committee, and others. Unreported judgment 2009/51933, 2011 ZAGP JHC2 at paragraph 77.
It's in your head.
It's in the heads, and actually in the preamble we open up with it. And that is a judgment of your brother, or former brother, CJ Klassen J. If we use that as our springboard, my lady, it's going to save us a lot of explaining and a lot of words indeed. Because to the extent that this case is about one question and one question only, namely, what limits ought to be placed on the considered freedom of expression of the SABC, because one obviously cannot say the SABC doesn't have freedom of expression. It does, like all other citizens or other entities. But what constitutional limits ought to be put on that particular freedom of expression of the SABC? Because A, it is an organ of state, and B, it is a public service broadcaster. In other words, what limits arise from that identity? Our courts, and that's why I headed up this case of McBride, because it expresses better than any other case that freedom of expression is not a carte blanche kind of right, which should be obvious. But we will demonstrate, my lady, that is the folly of the SABC stance, because they come from the point of view that the SABC has freedom of expression, which, as I say, we concede. But that means it can just do anything. Surely that cannot be. Not even a non-public broadcaster kind of free-for-all freedom of expression. And this is what His Lordship said in that case. And I'm going to be coming back to this many times, so I'm not going to comment on it for now. I'm just using it as the outline. The SABC cannot be equated with a private citizen or broadcaster who is entitled to freedom of expression. The SABC is funded by the taxpayer to provide the highest standards of journalism and fair, unbiased, impartial, and independent news coverage. Whereas the private citizen or broadcaster may freely take political sides and promote party political objectives, a public broadcaster may not use public money to do so. That, with the greatest respect, my lady, is beginning and the end of the contours of our case, and we will unpack some of the statements that are made there. Then, my lady, if I may, again, hopefully with the result that it will save us a lot of time and unnecessary debate, just take your leadership to a few points of what this case is not about, because that's always important. Otherwise, we're going to be debating here things that are irrelevant. And I'm saying this because, again, having read the answering affidavit and the SABC's heads of argument, and I hope I'm not being unfair, I think that there's a lot of it really is about. So let's start with what it is not about. It is not about allegations of censorship, my lady. Let's get that out of the window, because there's a lot of saying, no, the SABC did not censor differing views. We agree. Top class. We give them a big tick. It's not about the suppression of different views by the SABC in respect of this GNU debate. What the case is about in that respect is about the SABC's own adoption, its own adoption, mimicking, and what we call mouthpiecing, if there's such a word, of a term simply because it was improperly abused by the ruling party, the dominant party. The dominant party no longer dominant, and the government. And if I may pause there, my lady, the simplest facility to understand that debate is this: is to juxtapose, as I will when I get into my juxtapose what a state broadcaster is. Most of us, hopefully, listening to this will be old enough to know the SABC of old. So that was a state broadcaster, a mouthpiece of the government by any description. Fair enough. And juxtapose that against the SABC post-1994 and what it stands for, and what a public service broadcaster is, both locally and internationally, but more particularly in our context. Very simple. So if any conduct, if I put conduct and I say this is the conduct, and is this conduct reminiscent of the SABC of old, or of what the SABC now should be doing, then that exercise will make it clear. So please, nothing to do with censorship and nothing to do with suppression of views. We're simply saying that the SABC has wrongly and improperly and unconstitutionally adopted the nomenclature or terminology of the dominant party and the government. Secondly, the case is not about a complaint, because that also has caused a lot of smoke with no fire. A complaint, and this is in relation, of course, your leadership will remember from the papers, to the whole issue of internal remedies and so on.
Yes, but that's the Padger point.
Absolutely, only if we get there.
Only if we get to the Padger.
Absolutely, Madam. Absolutely. Well, that takes away my other point. Your leadership has already articulated it. But even if, in the unlikely event that we do, the complaint is defined in the Broadcasting Act and in the ICASA Act as well. And that is a complaint when you complain about a particular news item or a particular, something that affects you, and then you have to follow all those things. This is something completely different, and this point was made in the Islamic Unity case, which we'll deal with. We said, okay, yes, there's a complaint as well, but this is not what we're about here in court. In court, the court is here to regulate, not the complaint, but to regulate the Constitution, which is the job of the court. And insofar as the case has been pleaded as regarding constitutional breaches, the fact that there may or may not be a complaint as well is irrelevant. If there is, it will go to all those other places. The third point, my lady, is that, well, it's linked to the other point. The application is brought in terms of Section 172 of the Constitution, read with Section 38 and 33 of the Constitution. That's the Paja point. And in the alternative, the principle of legality. Your Lordship has just foreshadowed that, so I'm not going to spend time on that. The fourth point is a point that I've already made. The only defense on the merits, and I'll deal with the so-called preliminary defenses, is that the Section 16(1) of the Constitution gives the SABC, as I said, carte blanche to do as it pleases outside and places the SABC outside of the jurisdiction of the court. That doesn't even need to be dealt with. Then the last point, fifthly, is that oh yes, and this is quite important. To the extent that we cascade the regulatory regime until the editorial policies, Baledi, it's important to say upfront that the matter is not simply about the issue of accuracy. It's accuracy, yes, and it's impartiality, independence. Those are the yardsticks against which we would like the conduct, which is mostly admitted and common cause, to be gauged. What does that mean? In simple terms, and this is another mistake that I think my learned friends have made. Let's assume, for argument's sake, we're wrong on the issue of accuracy. Then we'll still have to look into the conduct against the measure of impartiality. Let's assume we're wrong there as well. Then we still have to look at it against the measure of independence. And if it fails on any one of those three, then our case will be made. And that's an important point. So that's as far as what the case is not about. Now, I've already touched on what the case in our respectful submission is about. And I want to paraphrase it again as follows. It is about the alleged breaches by the SABC of mainly the following provisions of the Constitution. Section 10, that's the dignity clause. Section 16(1)(b), or let me just rather say Section 16, with particular emphasis on 16(1)(b) and 16(2). Section 19 of the Constitution, the political rights of a citizen and of the party. Section 20, the rights to citizenship. And Section 32, the right to access to information. Read with the broader regulatory scheme, as my learned friends call it, and that moves from the Constitution to the legislation to the editorial policies and so on. And we say mainly because the conduct of the SABC excludes the applicants and millions of South Africans from political participation in their own country. I won't read out the whole list. Your leadership will read the same thing about dignity, about all the other
Yes, of
rights.
course, of course.
Now, and my lady, we're going to trace the justification or the support for that statement on various legal instruments, some in detail, some not so much in detail. And they include the following: the preamble to the Constitution, the values that are contained in Section 1 of the Constitution, Section 7, bracket 2 of the Constitution, the specific rights in the Bill of Rights, that's the list that I gave earlier.
Yes.
And then the relevant legislation, that's mainly the Broadcasting Act, the SABC Charter, and the SABC's own editorial policies. If we demonstrate, my lady, that any of these constitutional standards, provisions, call it what you may, have been breached by the conduct of the SABC, then the court must, as the wording of Section 172(1)(a) says, the court in this matter will have no discretion. It must declare that that breach has happened. But also it may, as 172(1)(b), now the court now has a discretion. It may then give just an equitable remedies, which we will talk about here. But it's important to emphasize that distinction, which was made in the case of, in the so-called Mdntv case, the EFF case, EFF 1, as it is known, by Mogoeng CJ. In other words, this court, the main relief that is sought from this court is really the declaratory relief. What the court does or doesn't do after that is a matter of subsequent debate. But the simple question is, have we, as the applicants, established a breach of any of these things that I've spoken about or not? If we haven't, we must lose. If we have, then the SABC must lose. It's as simple as that. So that's the end of the outline. Thank you, my lady, for that indulgence. So now we then go to what I will call the impugned conduct, because of course we all know Section 172(1)(a) says whenever a court finds, I'm paraphrasing, whenever a court finds that there is conduct or law inconsistent with the Constitution, then the court must declare and so on. So here we're not dealing with a law as in legislation, we're dealing with conduct. So which conduct then are we impugning? And here we are fortunate again, I will not spend a lot of time because again, the conduct per se is not disputed, it's not seriously disputed. My learned friends might differ, but my reading of their stance is what is colloquially known in law as confession and avoidance. In other words, they accept that the conduct or the classification that we complain about has been done, but then they want to explain it away, as it were. Unlike a case where there would have been a debate about the conduct itself or the factual matrix and disputes of fact and all that. We don't have any of that in this case. So the SABC is not saying that it did not adopt as its own official stance the term government of national unity. No. It's simply saying that it explains why it did so. And let me emphasize this, my lady, up front. I'm going to show your ladyship. In fact, one of my juniors said, well, it looks like the SABC's defense actually helps our case, broadly speaking. And I tend to agree. And I'll show your ladyship with specific references where that actually happens. Where literally, I mean, again, to use the word liberally, there's almost a confession of what we're accusing them of doing. But we'll take your leadership there. And in addition to those confessions, quote unquote, it's common cause. The following facts are common cause broadly. Again, I won't bore your leadership with references. Your leadership has read the papers. It's common cause that the watershed elections in May 2024 produced for the first time at a national level what is known in the broadly as the hung parliament.
Yes.
Which simply means no single party won the majority. Two, it's also common cause that the ANC, at its meeting on the 6th of June in Birchwood, came up with this notion of a proposed GNU, and I'm using the word proposed advisedly. So it said, well, we're going to go out and we intend to form a government of national unity. Nothing wrong with that. And three, it's also common cause that two parties signed the SOI, the thing called the Statement of Intent, which for us as lawyers is let's call it an agreement. It's a contract of sorts. And that it was signed on the 14th of June, my lady. It was signed by two signatories, Mr. Fikile Mbalula, Secretary General of the ANC, and Ms. Helen Zille, who is the National Federal Chairperson of the Democratic Alliance. Those are the people who entered into that contract, which at some stage I'll also call a marriage, just for simple
a marriage of convenience.
Analogy, yes. Yeah. But also to make a particular point. That's common cause. It's related to that. It's also common cause that in the affidavit we say 11, it's a mistake. 8 other parties, so 10, I think that's common cause. 8 other parties subsequently, shall we say, subscribed or supported that agreement. There's no evidence that they ever signed anything, but we all know that they are part of the marriage somehow. Now, here's the important point, my lady. It's common cause that it was a precondition, right? A precondition set by the DA that the purported government must exclude the MK party and the economic freedom fighters. Which parties represent approximately 25% of the South African electorate.
Is that common cause?
Yeah, well, it's common cause in the sense that it's not disputed. We have pleaded it, and it's not disputed, so it's common cause to that effect. But I think it's common cause at all levels, at least from my recollection of the agenda application, there was no dispute about that. Sorry, my lady. Which part are you saying is it common cause? The exclusion or the percentage?
The precondition.
Oh yes, yeah. No, that's common cause. That it was a precondition. You'll find that, my lady, in you'll find it in the founding affidavit, my lady. I'm just finding the actual passage where we talk about Doomsday Coalition. Can I find it? All right, I'll find the passage now, my lady.
Yes, take your time.
Yes, I'll read it. I think I just want to do it so that I get it out of the way. Okay, my Leonard Junior will find it. But yes, until I find it, my lady, it's pleaded specifically that the DA set this precondition.
Sorry, my lady, it's not an issue. I can confirm that.
Yes, thank you.
Thank you.
So
Thank you.
Thank you. I'm indebted to my learned friend. So it is common cause. Yeah. it's also, my lady, common cause. The percentage, again, I don't think you remember in MK1 we set out the various percentages of which party got what.
Yes.
Yes. Yeah. So let's then say, to round off that point, it's common cause that the DA set a precondition, which was, as we know in the law of contract, obviously accepted by the ANC, that those two parties must be excluded. And by so doing, by that act, the very foundation of the agreement, statement of intent, is the exclusion of at least 4 million South Africans from political participation or determining the destiny of their country. Then, my lady, it's also common cause now in the sense that, again, that it is not opposed.
Can I come back to what you just
yes,
said?
this is the important one, my lady, yes, please.
Yes. When you say they're excluded from participating, you're not saying they don't have a vote.
No.
They have a vote, and they have voted.
Yes, in the election.
In the election.
Absolutely, yes.
And they can go to Parliament.
Absolutely.
And they can make their voice heard in Parliament.
Absolutely.
So what you have said is qualified by that.
Yes, Melinda.
When you say they don't have a voice,
yes,
you say they are not properly represented by the term.
Yes. Yes.
Government of National Unity.
Absolutely.
Because as I understand the argument, your clients say it's not just a name. This is what they call themselves. But you say, no, it's not just a name.
Yes.
You say that it has, it's definitive of a certain model.
Absolutely.
Am I correct?
100%, my lady.
And you say that that model has a particular, is a term of art.
Absolutely.
A political term
Yes.
of art.
Yes.
It means something. It means something. So that is the starting point in relation to, as I understand it, in relation to where the argument flows from.
Yes, my lady. My lady, before, well, firstly, I agree with your ladyship. But before I respond to that, may I give your ladyship that reference? I know it's been considered, but just for the sake of completion, you'll find it in the founding affidavit, paragraph 64. That's 02-165. There's a lot of confusion about this numbering. I hope we're on the same page. 02-165. Yes. Or whatever other variation. Yes. Yeah. And it says, and I'm just getting rid of this, but I'm not going to belabor it because it's been considered. In fact, the DA, which is a signatory of the SOI, specifically stipulated the exclusion of these two major parties as a precondition to its own participation in the current government, which has been accepted by the ANC. The DA characterizes any coalition which includes these two excluded parties as a doomsday coalition, which must be avoided at all costs. But coming back to what we're discussing now, my lady, your ladyship is 100% correct. That do they have the vote? Yes. Do they participate in the legislative arm of the state? Yes. Well, the exclusion, my lady, is the exclusion, firstly, as I say, from the so-called agreement, but the legal effect of that is the exclusion from the executive arm of the state. So, to the extent that there's an exclusion, I accept your ladyship's qualification. It is a qualified exclusion. I can't argue against that. So, at best, let's say it's qualified to the exclusion from participating in the executive arm of the state. But our respectful submission, my lady, will be that political exclusion is political exclusion. Whether it's exclusion from this but not from that, it's like what happened during apartheid. You might have said, no, you can swim here, but you cannot swim here. The fact that you are allowed to do certain things doesn't diminish the exclusion from what you are excluded from. So that is that exclusion, qualified as your leadership correctly points it, is a hallmark or a fundamental idea, foundational idea of the so-called government of national unity. Now, and we will argue, my lady, very vociferously that just like apartheid itself, any arrangement whose foundation is the exclusion of millions of South Africans, or at whatever level, cannot be called national unity without insulting those people. Because if national unity is not it's not just a loose term, it's a legal term. It has been dealt with, my lady. There's something called the National Unity and Reconciliation Act of South Africa. There's a lot of case law, not least of which the McBride case, where the concept of national unity is dealt with extensively by the Constitutional Court. So, leadership captured this. I was smiling when the leadership was giving that summary, because that really nabs into what we're talking about. That this is not just a name. No, it's not a name like Mary or Temba, which it's a concept which has, as your leadership correctly said, some meaning, and we're saying that this government might be a government of all sorts of things, but it's not a government of national unity.
But where does one find? And I think that we have to, that's the second place that we have to start.
Yes.
So we understand it's not just a name,
Yes.
it's a political term of art, if I can term it.
It's a definable thing.
And what does that, what are the ingredients
of that?
Of what a GNU is?
Yes. Okay.
Because I see that you rely on definition.
Yes.
You rely on a political, an Oxford dictionary of political terminology for a definition.
Correct.
And what we know is that there have been governments of national unity through the ages. One of the more famous ones was when Churchill took power after the war.
Please, I'm not out of disrespect as you're speaking. Can I try and
Of course. So please do what you need to. So we know that national unity is something that has been part of international political
discourse.
Yes. And are we not directly in that discourse here? We're determining what the term means.
Yes, my lady. My lady, yes. So I'm not patronizing your leadership, but that's an important question. Let's do it like this, my lady, because this is a crucial part of the case. If we go past the fact that it's not just a term, it's a definable term. Then secondly, we say, what are, which is really your leadership's questions, what are the features? If I say this is a bus and not a car, we say, why are you saying it? I'll then have to explain why.
Yes.
The leadership is quite correct. And then the third aspect of your leadership's point is that what is the idea that it symbolizes? Whether it's Churchill's GNU or the Mandela's GNU.
Or Israel, or there are countless
Countless examples.
China.
Yeah, absolutely.
So we do have it as part of a political.
Yes.
It's positioned as part of a political.
Absolutely. Yes. Just as we know.
Ideal.
Absolutely. Yes. Just as if we say constitutional democracy, we know what that means, and there might be variations from country to country, but we know what that means.
Yes.
The leadership is quite correct. Now, let me answer the question, Malika. Firstly, we start with what I call the dictionary definitions. And obviously, they were also drawn from what leadership and I just discussed. And the Oxford Dictionary of African Politics defined it as one that brings together a number of rival leaders and political parties in order to promote national unity. And you'll find that at paragraph 61 of our founding affidavit, which is 19-164, I think. Yeah. Brings together a number of rival political parties in order to promote national unity, underline that, and political stability. Governments of national unity are often formed after a political crisis, so that's one of the things, after a period of conflict or during a transition from one regime or another. That's what your leadership and I just discussed. Wikipedia says it is, and this is a more exact, it is a broad coalition government consisting of, underline, all parties or all major parties. Just underline. So it's either all parties, in other words 100%, or all major parties in the legislature, usually formed during a time of war and other national emergency. That, again, we know what that is. So, my lady, from these definitions, and I'll go to others, the two things that come out are the following. That you have, and we've put in there, and that has not been denied, that the average is 85%, 90%, because you may never get 100%. But it has to be a substantial high number of participation. 100% would be great, but 85 to 90% is accepted.
But that is an incident of the political debate.
No,
it's not. The percentage is an incident of the political debate.
Yes.
So where you say, well, it's got to be 90%. Well, what if it's 70%?
Yeah.
At what stage in the debate does it fall below the required, the required majority,
yes,
the notional, if you like?
Yes.
Required majority.
Yes, I hear your leadership. No, it's not a function of the political debate, because if we say to change the constitution, you need a substantial amount for certain clauses, not less than 75%, let's say. Then that's it. Then once that threshold is set, it's set. You can't say, well, what if it's 74? Well, if it's 74, it's not certain.
Well, yes, but this is not an exactitude.
Well,
it's a political debate in relation to what that sliding scale means, what it reaches, what it doesn't reach. And as you say, it's not a 2/3 or of that nature. We're not talking about percentages on the basis that they are laid down as required. We're talking here, as I understand, about ideology.
No. Absolutely not, Malay. No, it's not ideology. It's quantum. We are saying that if you have a government that is 51%, you can't call it a government of national unity. All right? That's a question of science. It's not that is not a government of national unity.
Look, you can call it a government.
Yeah, you can call it a government. Yes, of course.
Whether you can use the word unity and in what context that can be used is the debate that you are having.
Yes, absolutely.
It's the debate that is being had.
Absolutely.
Now we know that there that national is a term that is also a political term of art.
And
It's
unity.
used. So if we take national, your client, as an example, calls itself the spear of the nation.
Yes.
So there's a national element
Yes.
there.
Absolutely.
The ANC says that it is a national Congress.
Correct.
And this is true all over the world. One wants to, by using this term, one wants to promote inclusivity.
Absolutely.
So that's where we are in relation to the debate.
Yes. Yes.
And
I'm with you. on that.
and we are having this debate because it's an ideological debate.
No, okay. My lady, with the greatest respect, it's not. We'll get to the ideological debate later. This is a matter of law. Is there a majority government, let's say, for example? What is a majority government? A majority government is that which represents 50% plus 1 of the electorate. That's it. It's nothing to do with ideology. It could be the fascist government or a communist, it doesn't matter. If it represents 50% plus 1, it's a majority government.
Because that's the model.
Yes.
That's the electoral model
Yes, yes.
and the executive model that we follow
Absolutely,
in
yeah.
South Africa.
Yes. So that's where I am now. That okay. Let me put it more crassly, my lady. You cannot. Let's take the word national.
Yes.
Now, yeah, a political party can exaggerate its importance and call itself the international party of this with 2 members. That's fine. Yeah. Okay. And the global universal party of the world. Yeah. Nobody is going to stop them from doing that. So whether but the word national in a court of law must have a meaning, right? National in this context means South Africa, right?
It's of the nation.
Of the nation as a whole,
Yes.
right? Now, let me ask a rhetorical question. Can anyone say that something which excludes 4 million South Africans is national? No.
Well, maybe they can't. But in the same way, because that's inaccurate, but in the same way as the example you've just given of the enormous exaggerated name party, that's inaccurate.
Yes.
But does it mean they can't call themselves that?
No, my lady, it doesn't. They are free to do so because they are not the SABC. But the SABC, which is a national public broadcaster, cannot feed us as citizens with inaccurate information.
But
So,
is it inaccurate to say this is what they call themselves? They call themselves the GNU, and we're calling them the GNU
Yeah.
because that's what they call themselves. In so doing, we are not aligning ourselves with any one or other position. And the Democratic Party, we may not think that they're very democratic at all. But we can't come to court and say, well, you can't say you're democratic because that's an ideological
Yes.
debate.
No, my lady, I'm trying again.
Yes, no, please.
Yeah, this has nothing to do. The Democratic Party can call itself whatever it wants. It is not an organ of state, and it is not a public broadcaster. So it is free to call itself whatever it wants to call itself. We are here in this court about an organ of state and the duties that accrue from that fact that you are
Yes,
an
but
organ of
let's
state.
just back up because we are not talking about when you say we're talking about an organ of state
Right. And the public broadcast.
and a public broadcaster,
Yes, my lady.
whatever I say after this very interesting argument,
Yes, ma'am.
and I acknowledge it's an important argument, and it's something that we have to grapple with
Thank you.
seriously.
I appreciate it.
When all is said and done, a case like this is important because it will set a precedent.
Absolutely.
So I say, well, you can't call yourself a government of unity because you're not a government of unity. And we accept factually that that is not the case. So that is a term which is inaccurate, and it's a name that you call yourself, but you may not use it.
Sure.
That precedent will mean that somebody could come to court and say, you can't call yourself the Communist Party. So I am bringing to court an application that says whenever the SABC uses the term Communist Party, it's far more than a name. There's an ideological basket of things that it means internationally in political discourse.
Correct, my lady.
And you can't call yourself a communist party if you're not a communist party, because what about the people that are really communists?
Okay.
There are millions of them, and don't they feel that they're being misrepresented?
Yes. Okay. My lady, I'll try for the last time. The Communist Party or the Liberal Party or whatever, if the day it becomes an organ of state and then it becomes a public broadcaster, then it cannot call itself inaccurately. Your ladyship has correctly used the word inaccurately twice. So that's the nub of the issue. The SABC is not allowed to give inaccurate information.
But
Now-
it can call somebody by its name,
No.
even if that name is an inaccurate name.
No, my lady. Your ladyship,
And my example of the Communist Party, to say, well, the Communist Party is not an organ of state. Well, it's an organ, and it has a particular political identity.
yes.
The question is not whether it's an organ of state or not. The question is, can the organ of state in issue, the SABC, can they use the name Communist Party if somebody comes and says, no, that's a completely
No. Okay.
that is completely at odds
I hear
with
you.
Marxist theory.
Yes.
And your manifesto is this,
Yeah.
and Marxist theory says
Is this,
that,
yes.
and you can't call yourself.
the Marxist Party.
And if you call yourself that, then we're not allowed to say that you are the Communist Party.
Okay.
We have to say that you're the so-called Communist Party,
Yes.
for example.
Okay. We're getting to the right place then, my lady. Without being waylaid by the examples.
Yes.
Let's come back to the principle.
Yes.
The principle is this, my lady. Whenever there is a national debate about something, and that national debate, irrespective of the merits, who's right, who's wrong, but the fact that it's a debated issue, the SABC is by law not allowed to take sides in that debate. So let's accept that. I don't think anyone's going to argue with that. That's what Klassen J said. That he actually used those words. He said it cannot take political sides. So that's a tick. The second issue, my lady, is that is what your leadership calls so-called. And your leadership is quite correct. if the SABC, then there is that debate, its behavior must indicate that there is that debate by either saying the so-called or in fact, ironically, my learned friends in their heads do that, but it's too late now. They say the so-called government of national unity, and they say they put it in inverted commas. It's too late. We don't want it from them. We want it from their client. So the leadership is quite correct. So the SABC's duty is then to reflect, because it can't say if the Springboks call themselves a netball club. The SABC can say, well, the netball club just won the Rugby World Cup. It has to say, well, the so-called netball, because that's what they are calling themselves, as the leadership say. But we know that they are not. But it can't say, good morning. Today the netball club was playing against the All Blacks. It can't, because the SABC has a duty to give the citizens of this country accurate information. And I take your leadership's point. They're not going to go and argue with those rugby people and say, you're not a netball. That's not their job. But they must then indicate, because there'll be a national debate, are they a rugby club, are they a netball club? Then they must say, well, the so-called or the... But what they may not do, which is what happened here, is to adopt for themselves, not to say these people are calling themselves this, but to say we are adopting it for ourselves, that they are the netball club.
Well, can I tell you why I don't find that analogy helpful? Because when you are dealing with one sport or another, it's not a political debate. Communism, democracy, governments of national unity, what they mean, what they don't mean, these are political debates. And what I'm asking you is this the place to have those debates, this court?
Oh my God. No, my lady, I hope your leadership is not attracted to that. My lady, if we come here and we say this thing is calling itself a political party, right? But it's not a political party, legally speaking. How can you say that's a political debate? That's a legal debate about the definition of the thing. It doesn't matter if it's about religion. The other one calls it a church, calls itself a church, and we say it's not a church. And the court will say, no, that's a religious debate. No, please.
It may be.
Yeah, it may be, but in a court of law, it's about...
It may be a religious debate, and
that
may not... That may be a place where the court should not tread.
Oh, well, then we must abolish the court system, because every case is about something.
You're wanting to put me out of the job?
Yes, without causing unemployment.
Before your ladyship's age of retirement.
Normally, on a serious note, there is no. I was explaining this to somebody. There's no such thing as a court case. There isn't. A court case is about something. It's about an accident. Somebody crossed a red robot, but that's the case about that. It's about a debate in a church. It's about a debate in a sporting field. It's about a debate in a company, whatever. Then we must never, it's about our water, it's about this or the other.
Well, it's about rights.
Yes, it's about rights. So, and there is such a thing in section 19 of this book called political rights, right? So this notion, which is really obnoxious, put by our learned friends, that this is not about the legal issues and obligations of the SABC as a public broadcaster, but a political debate. Well, the fact that it's a political debate does not mean it's not a legal debate. Otherwise, we wouldn't have political rights here. Okay?
Well, when you say it's a legal debate, we have to come down to definitions. What is a GNU?
Yeah.
And I think that's where we started.
Yes, that's
this
exchange
testing
yes.
that we're doing
yes.
between one another.
Yes.
So how does one define a GNU?
Thank you, Malady. Yes. Okay.
Because and as I said to you, the difficulty I have is it about percentage? It can't be.
Well, it must be also about percentages, my lady. With the greatest respect, are you going to have like that's what I said? If it was 2%, can call it a government of national unity? No. If it's 40%, is it a government of national unity? No. If it's 51, is it a government of national unity?
Well, it wouldn't be 2% because our electoral system doesn't permit of that.
Fair enough. Let's start
so
at 50.
Let's start at
50 plus 1. Yes. Let's say 50% plus 1.
Yes. So
then
we have a government.
Yes, we have a government.
So then we have at 2% we don't have a government. Yeah. So we have a government. We have the fact that the government is entitled to govern.
Yes.
It's entitled to govern.
Without putting words in your mouth, my lady, we concede that it's a government. So let's not.
Yes, of course. So we then come to the third leg of it, and that is unity. And I think we know that
it's not national.
It's a government. We know that the government governs the nation, and we know that it calls itself this conglomerate, if I can term it that. They call themselves a GNU. So I think the term that we come down to is what is unity, and is that not where the debate resides, and is that not where the debate has resided for decades within the political sphere?
Yes, my lady, the answer is no. But I'll also address, if your ladyship is correct, what the answer is. The answer is that it's not the term that is under, as I said, we concede it's a government. It's a government. But the term that is under contention is national unity. It's not just unity. And I'll explain why. And the national is what do you call it? Adjective. Unity is the noun. So it's the government of national unity. Okay. So let's start with the adjective. I'm saying, my lady, that something which is not, and I'm talking legally now, forget about politics. Something which is not representative of the nation as a whole is not national as a matter of law.
Well, then the ANC can't call itself the ANC.
Okay, well, I've already answered that. The ANC can call itself anything it wants. It can even call itself the party from the moon. Yeah. But I'm saying, if we come here to court and we say, okay, now the point we are debating is whether it's a party from the moon, the lordship will say, of course. They may call themselves that.
If I say, and set a precedent, because that's what we do here, for better or for worse. If I say, given political contention around a particular name or term, if there is that contention, or if that contention reaches a particular point,
correct,
then you may not call yourself that, and the SABC, whether you call yourself, you can call yourself anything you want. But the SABC may not call you that. Even if you call yourself an African National Congress, well, somebody might say, well, it's not African. No. This is not the manner in which your manifesto reads cannot encompass the whole of of Africa. So it's not African.
My lady, I'm not going to address that again. Simply to say that a party can call itself whatever it wants to call itself, and that if there is a national debate about the name ANC, that's a different matter. But if somebody comes, that doesn't wash. But if there was ever a national debate, a serious national debate about whether it's African, then the SABC at that point will not be entitled to say, oh, these ones are crazy. It's the African. They'll have to, if at once there is a national debate, and I think that's what's missing from what we're debating, is that when there are controversial matters, and my learned friends have considered this point somewhere in there.
Yes.
That it's a controversial. Yeah.
There's always controversy in politics.
Well, there's controversy in everything, my lady. The controversy could be about whether this is the Catholic Church or not. Let's forget this politics thing. We could be here about whether this church that just formed itself down the road is entitled to call itself the Catholic Church. Okay? So this politics thing is just a red herring.
Well, that's why let's take it out of the political arena.
It's a red herring to scare the court into saying, no, we're not going to enter a politics. Forget the politics. Assume it was about the church.
You see, then to create that platform,
yes, my lady,
anybody could start a debate. And then the question would be, well, is there a national debate? In the Dark Ages, there certainly was about whether Catholics were right or whether Protestants were right and who should be burned and tortured.
Absolutely.
So that was a big debate.
Yes.
So now if you have that debate, what if you have no debate, but the party starts a debate and then comes to court and says, well, now there's a debate, because there was a stage when this debate didn't start, as I understand it, with the name. It started after the name.
No, it did.
It started with the name.
It started with the name. The facts, yes. My lady, what if, the facts before you are the facts before you. What if someone started a debate? Well, I don't know. But on the facts before you, the debate, my lady, was started. Can I come back to that, because I've now lost the point that we were.
Yes, I'm sorry. Don't let me take you out of your train of thought. That's not what my probing is for. I want to get these things right in my own head.
Absolutely.
Because I'm the one that's got to write this judgment, and you say that it's important, and I want to get it right,
yes,
Mr. Mpofu.
No, I know. But I'm just saying, my lady, I'm apologizing to you to say
yes.
The fact that I'm going to that other topic doesn't mean I'm not going to answer what you say. Yeah. I just want to complete the point that I was making, which is that the concept of national unity in South Africa, anybody who thinks that is a plaything is really in a different world. National unity in this country, it has been explained in the case of McBride, is something very, very serious.
Very serious.
And something which must be built, and something which must not be made a political plaything, or people think that it's it can just be frivolously proclaimed.
But there's no reason why people can't have serious debates outside of a courtroom.
No, that's not what I'm saying. I'm saying national unity is a specific constitutional concept.
Yes.
Let me just leave it at that. Yeah. And by the way, to come back to you, there's also this notion that government of national unity is I don't know, is something made up by politicians. If you go to Annexure B of this book, you will find the following heading: Government of National Unity, National Sphere. And then it goes on for many sections. And then later, it says Government of National, Annexure C, Government of National Unity, Provincial Sphere. So the government of national unity is not something unknown to our law. We don't have to be debating whether is it a nebulous. It's a legal concept.
Well, it's not defined.
No, it might not be defined, but it's a legal concept. Okay, then of course we are here. If it was defined, we probably wouldn't be here. If it says, yeah, an orange is something with this and that, then we can't come here and debate what it is. Yeah. We come to debate here because it simply says, well, there's a fruit that is this and the other, and then we have to come and debate whether it's an apple or an orange. Okay. So the point I'm simply making is that government of national unity is a legal term, a constitutional term. It exists. It has been referred to in, sorry, my lady, if leadership, just give me 1 second.
Yes, of course. Take your time, Mr. Mpofu.
Yeah. One of them. In that case, 233, it must be Ngobo. Ngobo CJ said this. Freedom of expression, bringing it home now to it. Yeah. Freedom of expression is a right to be exercised with due deference to, among others, the pursuit of national unity and reconciliation. It can be the ground for excusing the citizen of the newspaper. That's not the point. But the point I'm making to you, my lady, is that the Constitutional Court and the Constitution have used this term. So it's not just a term, grabbed from the air.
They've also used the term democracy.
Yes, which is also more important.
They use many, many terms. But the question is whether I can say that the SABC is not allowed to refer to the name because of the ideological debate. So we know they call themselves the GNU. In the same way as we know what your party calls itself, what other people's parties call themselves, we know. And that's a matter of common knowledge out there.
Okay, let's leave that, my lady, because I don't think it's going to...
Perhaps
I can't.
Perhaps it's an opportune time, Mr.
It is, my lady,
for the tea adjournment.
Yes, it is. But can I just throw the next debate without building on it? My lady, this case is about one thing and one thing only. And it is about the obligations of a public service broadcaster. Let me put it like this, my lady. The SABC of old, which is what we are juxtaposing this against, called the organization you just spoke about, called Nelson Mandela a terrorist.
Yes.
Okay? The only reason they called Nelson Mandela a terrorist was because the government of the day called him a terrorist. Right? And in the same way, a public broadcaster that says, actually they say it in their own words, that says to you, I'm only calling it this because the state calls it that, or because the ANC called it that, or because the president called it that, is behaving exactly in the same way as the government that called Nelson Mandela a terrorist because he was called, not because it had made its own research or whatever, but simply because the state, the powerful state of the day, called it that. So I'll develop that when we come back from.
Thank you.
Thank you.
We'll adjourn until 11:30.
Yes. Yeah. Thank you very much.
Yes, Mr. Mpofu.
Lady, yes, as I said, I don't want us to fall into the folly that I was accusing my learned friends of just dealing with the issue of accuracy, because that's just one issue.
Yes.
It's still the issue of impartiality and independence.
Yes.
But to round off this issue on accuracy, I want to say this, Malik. Well, let me start with the more serious submission. Your leadership has, and I really am indebted to your leadership for stating that your leadership realizes the importance of this debate, hence the engagement, which I also appreciate, Malik. But I just want to say that, in the McBride case, to emphasize the seriousness of this case, Ngobo CJ said at paragraph 169, those who cannot remember the past are condemned to repeat it. And that statement, my lady, really encapsulates what we are here about. If we don't know the danger that can happen when a public broadcaster becomes the mouthpiece or the echo chamber of the government of the day or the dominant party.
And we've seen that before.
Everywhere, Malone, not just here. We've seen it before here, yes, but we've seen it in Iraq, we've seen it in Israel.
But
we've
from a
seen it
personal
everywhere.
perspective,
Yes.
we've seen it here.
Absolutely. Actually, yes. We don't need anyone to tell us about that.
Tell us about
Yes,
propaganda.
Correct, my lady. Yes. So this is what we are busy about. So if, my lady, there is a public broadcaster, know-how, that says in its own mouth that we are using this term because the government uses it. They say it themselves. That's what I call the confession. It's not your leadership will going to have to say no, they are lying. But that's what they say under oath, that we are doing this because the government uses it. What is the difference then between that and what's the definition of a mouthpiece? A mouthpiece literally means a mouthpiece. An echo chamber means an echo chamber. They just hear what is the government saying and repeat it, without processing it through any process of any sort. That the dangers of that, my lady, are bigger than if you poisoning the minds of people is bigger than if you poison them with poison, physical poison. Because that, as the great Steve Biko said, the greatest weapon in the mind, in the hands of the oppressor, is the mind of the oppressed. Not the guns and the tear gas and all that. It's the mind control. So this is what we're about. So it is no answer, with the greatest respect, my lady, to say, well, we're saying it because they are saying it. Actually, that assists our case, because that's exactly what you are accusing them of. Now, on a lighter note, my lady, apropos the debate that we're having, about how official people define themselves, all the examples. This is what the Ugandan dictator Idi Amin's official title was in Uganda. And every time they had to do the news, they had to do this. His Excellency Presidents for Life, Field Marshal Alhaji Dr. Idi Amin Dada, VC, DSO, MC, Lord of all the beasts of the earth and fishes of the sea, and so on and so on. It goes. And it went on for about every 5 minutes they had to talk about him, they had to say all these things. And of course we know he also called himself the King of Scotland.
Yes, he did.
Yeah. So the point, my lady, with that tongue-in-cheek analogy is that it would be no answer then for the Ugandan Broadcasting Corporation or its equivalent to say, well, we know he's not the king of fishes and the king of Scotland, but that's what he calls himself. Because what they were doing was simply being the echo chamber and the mouthpiece of that nonsensical claim. So that's on accuracy. So the SABC's editorial policies say that they must adhere to the standard of accuracy and the highest standard. And my lady, we wouldn't be here if they did what your ladyship has said, and said there's this debate, the so-called government of national unity or whatever, but to adopt it as the gospel truth and spew it to the public as the gospel truth is wrong, is in breach of the and the Noble CJ went on to say, to my mind, conduct, and this is really what this case is about, conduct that threatens nation building and national reconciliation is inimical to our constitutional democracy. It would indeed undermine our constitution.
What was he talking about there?
Okay, he was talking here about the conduct. What had happened is that the equivalent of the SABC there was the Citizen newspaper.
Yes.
And the Citizen newspaper had called Mr. Robert McBride
Yes.
a murderer and
Yes.
whatever because of his crimes.
Well, alleged crimes.
Alleged
Yes.
crimes. Well, I think he
Yes,
was
at the
actually
time,
convicted.
yes.
Yeah. Of his previous crimes, let's call it
Yes.
that. I'm just paraphrasing. And Mr. McBride obviously then came to court to complain that this was defamatory and the usual. And I think the lower court had found against him, and the SCA, I can't remember, but the Constitutional Court said this. Constitutional Court said, because of the standard of national unity and reconciliation, for the citizen, and the citizen came like what we're debating. They said, well, the man
Was convicted of
murder, so
Yes.
we can call him a murderer. It's virtually through public benefit and all that jazz. But the Constitutional Court said no. The goals of national unity and reconciliation permeate our constitution. That's why we call it a transformative constitution. When we talk about healing the divisions of the past, which you find in the preamble to our constitution, we mean exactly that. And that goal supersedes everything. And therefore, to, as it were, conduct yourself in a way that threatens nation building is inimical to our constitutional democracy, and it undermines the constitution.
And what was the order there?
Sorry, my lady. So there were 3 judgments. I think the main judgment was Cameron judgment,
Yes.
which is the first judgment, and then the judgments by Nobo CJ Mkhwengu before he was Chief Justice. The order said, my lady, and you'll find that at paragraph 136, the citizen application for a leave is granted. The appeal succeeds, that is Mr. McBride's, that's
Yes.
order number 2.
Yes.
The appeal succeeds to the extent that the order of the SCA is set aside and replaced with the following order. The plaintiff's claim is dismissed except in relation to the defendant's claim that the plaintiff was not contrite. The plaintiff is aware of the damages of, whatever is awarded damages of 50,000 costs of the trial, and Mr. McBride's application for leave to cross appeal is refused. There is no orders to costs. Yeah.
Yes, thank you.
So yes. So the relevant part, my lady, of what I'm citing the case for is that it's traversed more than any other case, and that's why I just handed it up, because I only found it yesterday.
Yes, thank you.
Yes. It traverses more than the relationship between this issue of national unity and our constitution. And your ladyship will read it in your ladyship's own time. But just also to an issue that we left hanging, where I didn't respond to your ladyship, about where did the genesis of the complaint.
Yes.
Yes. The genesis of the complaint, my lady, was in what is quoted, or at least from the papers. I'm sure there might have been other complaints.
Well, I must confine myself
Yes,
to the papers,
to the
and I
papers, yeah.
certainly will do that.
Yes, yes. But as far as the papers are concerned, the complaint was articulated by former President Zuma, the first applicant, on the 23rd of June. That would be about a week or so after the
announcement.
The announcement.
Or
The
the
formation.
invitation.
After the remember, it was signed on the 14th.
Yes.
So it's a week after that.
Yes.
The signed signature of the state. So it was even before the executive was appointed, because that was done on the 30th.
Yes, thank you.
And he said at paragraph 41, regarding the current political situation, we need to educate our people that there is no government of unity in South Africa. There is only, he didn't say that. There is a white unholy alliance between the DA and the ANC of Ramaphosa. It is sponsored by big business. It is for the benefit of the markets, not the people. It must be crushed before it finds its feet. The media is also selling the story of a government of national unity when they know that there is no such thing. I know because I was part of the leadership which introduced a GNU in 1994. We have asked our lawyers to write a letter to the SABC to stop deliberately misleading South Africans by using terms like government of national unity and so on. Then he says later, which goes to the class in J, we know that private media has to serve its masters, but the SABC belongs to us. It has no right to feed our people with the lies and to pursue narrow agendas at our expense. We shall seek an urgent meeting with the SABC board and so on. So that was the first articulation of the complaint.
Thank you.
And then, my lady, which is, I keep on saying I'm moving away from this accuracy point, but there's so much on it. We of course then refer, my lady, to the following statement, which you'll find at 02-697 in reply. That's the statement of Ms. Helen Zille.
Yes. She says it's not a
Yes,
government.
she says, President Cyril Ramaphosa came up with the notion of a government of national unity, which he thought would be a better way of selling the concept of a coalition to his own party. Let's pause there. So he said he conceptualized or invented, or I mean, obviously not the term itself, but in this context, yeah.
Yes.
And then she says, very important. Now, this of course is not the government of national unity. And she doesn't stop there. She explains why. She says, because a government of national unity brings all the parties together, which would have to include the EFF and the MK party, Umkhonto weSizwe party, which it did not. In other words, it excluded those, as we debated earlier. But, and here's the important part of the motive, but it still gave the president the fig leaf he needed to bring in all sorts of smaller parties to say, I'm not in a coalition with the DA. Now the truth, she says, the truth, which is what the SABC is supposed to pursue. The truth is that we are actually in a coalition, because a coalition means that if a party withdraws from the coalition, the government fails. Now, she is 110% correct. She actually captures this whole debate we've had this morning about the accuracy. Because she says, A, it's not a government of national unity, and she says why. B, why was the lie had to be told? So fig leaf. Fig leaf is literally fig leaf. It's what happened in the garden.
You put it over the
Yes,
the nether regions if they offend you.
The truth, yes, it happened
As a statue.
with Adam and Eve. Yes, the fig leaf is what she used to hide the truth. So she says that former President Ramaphosa. Sorry, that's a Freudian slip. She says that President Ramaphosa is using this fig leaf effectively to hoodwink his colleagues into this. Now, let me be the first one to say this. President Ramaphosa is entitled to use whatever fig leaf he wants to use to his colleagues in the ANC. That's not what we're debating here. What we're debating is whether the SABC is entitled to adopt that fig leaf and spread it to the country as the gospel truth. When the author, this is one of the two signatories to the statement of intent, says she should know more than all of us. I don't want to bring the rules of the law of contract, but we know that the person who actually drafted the contract or signed it probably knows better what they meant. But she says, this is not a government of unity, it is a fig leaf. So if anyone wants to say, well, the SABC is wrong in saying themselves that we did this because the government is doing it, and Ms. Helen Zille is also wrong in saying it's not a GNU, well, good luck to the country if that is what we're going to do. Now let's go quickly to the question of impartiality. My lady, this is what your brother Klassen J, the second leg of his famous dictum, where he talks about, he says the SABC may not freely take political sides and promote party political objectives as a public broadcaster because of the taxpayers' money and so on. Use the taxpayers' money. So, here we know that the genesis of this thing was in the statement issued by the ANC and in the SOI. Now, and we know now that there was a contra-review seriously expressed by the MK party and former President Zuma, which specifically gives the other side. And we know that the SABC chose the one side. So, my lady, let me illustrate this point as follows. Well, maybe not us, but somebody would have been equally entitled to be here before you, my lady, and say that the SABC calls the government a white coalition, whatever the former President Zuma said, and big business. That would be equally wrong, because in so doing, the SABC would be adopting one of the contending issues. So it's not right, it's not wrong just because they have adopted the opposing side. It would be wrong even if they had adopted our side. Because and that's why you look at it like this, my lady. What do you call it? The DA says if there was a coalition between the ANC, MK and the EFF, it would be a doomsday coalition. That's what they call it. Now imagine if that coalition took place, and every time you open the news, the SABC says, well, today the Doomsday Coalition decided to I mean, it would be as wrong as to call it whatever that coalition would call itself. Because you cannot, and this is unfortunately something I have personal experience of. The duty of a public broadcaster internationally is to support democracy, to support the projects of national unity, and so on. And let me say this, my lady. You know, my lady, going back to the question of nation, the population of the Northwest is about 4 million people. Population of the Free State and the Northern Cape put together is about 4 million people. Now imagine this. I know it's a ridiculous proposition, but think about it. If we had what we call a national election, but we say the people of Free State and the Northern Cape may not vote at all, they're not.
Well, it's not that ridiculous because it's happened before.
Well, exactly. Thank you, my
But
lady.
with different limitations.
But with different permutations and criteria. Thank you, my lady. I'm indebted to that. So if that happened, and we say why? No, we say no, just because they live there or because they have these views or whatever. And then we say, yeah, well, we have a democratic election. And then the government that comes out of that calls itself the democratic government. And the SABC calls it the democratic government. We can't say, no, well, that's what they call themselves. The question is, can you call something which has excluded so many millions of people from itself the democratic government? The apartheid government, the leadership is quite correct, called itself the democratic government. They called Bophuthatswana a country, but it was not. So the point is that simply because that particularly dominant party or the government. Remember, when we talk about independence, my lady, I'm now I'm trying to do both impartiality and independence because I don't have much time. Independence mainly in broadcasting, in international broadcasting terminology, means independent from the government and from big commercial entities, because those are the powerful players in society. Now, this is not to say, and again, I know this from personal experience, the state and the big capital put pressure on the SABC every day. And there's nothing wrong with that. They want to wield their power. But what is wrong is for the SABC to succumb to that pressure. That's where the constitutional problem comes. It's not the existence of the pressure. But if because I'm a big advertiser and I say you must call a cat a dog, and then you do it simply because you want my advertising revenue, then you are breaching the code and the constitution. Yeah. Thank you, Baledi. Now, so impartiality is about that. Impartiality is about what Klassen CJ Klassen J. I'm sure he always benefited from those initials.
I know that you're using it to designate between the Klassen brothers.
Yes.
I appreciate
yes,
that. Thank you.
But conveniently, I would use my initials if they were that as well. Mine are DC, unfortunately. But
so am I.
Oh, great! Yes. So when he talked about the duty not to take sides in the national in such a national debate, that's exactly what he meant. He meant literally. I mean, it's like you're a referee, and then you just jump up for joy when the other side scores. Yeah. That's basically the duty of impartiality.
I understand what impartiality is.
No, I'm saying in this context.
In any context, I understand it.
Well, okay. Let me put it this way. In the context that Klassen J was imposing as a duty on the SABC,
yes,
it was with regard to a controversial topic. And in this case, I think paragraph 39 of the respondent's affidavit, the answering affidavit, they've said that at best it's a controversial. But even that concession, by the way, is fatal, because in the editorial policy, there is a reference to a controversial topic. That when the topic is controversial, this is how it should be treated. And
you must invoke a measure, a measure of, or a measure of measure.
A measure of measure, yeah. But we know, in other words, it's not business as usual. Yes. Your leadership, we'll give you the reference and reply.
Thank
the specific reference. So then we say the following. Assume and as I said, my lady, the SABC's only defense, apart from all those other fanciful things, at the beginning about whether it's a political this or whether it's the exhaustion of internal remedies and so on, is that it was exercising its right in terms of Section 16. Now, as a matter of law, my lady, that defense is unsustainable. Why? Because Section 16 of the Constitution itself contains its own internal limitations. And I don't know if your ladyship has had time to read the article. We sent an article on Friday, we uploaded it. Yes, there's an article, I won't go into it. Your ladyship, again, will read it in your ladyship's own time.
Yes, thank you.
But
Who is the political commentator that wrote it?
it's an academic book. Somebody called Joanna Porter. We've uploaded it. You'll find, your ladies will find it at 19-978.
Thank you.
It's called Disinformation and Democracy in Africa and South Africa. Excellent article which deals with even this McBride case and all the cases that both my learned friend and I have relied on, Islamic unity and so on. And
when I read the papers, it wasn't yet uploaded,
Okay,
but
no.
I will go back.
I apologize, ma'am.
And
Yes,
I will
you'll find
certainly
it.
read the papers again
Yes, my lady.
with your submissions in mind.
And whatever we've submitted. Thank you, madam.
Yes.
And the point I want to make is made as follows in that article at 9-1001. The role of the press and media, however, is two-dimensional. Their right is protected by Section 16(1)(a), but they must also fulfill the duty to society. The court addressed this in Kumal versus Olomisa. We've both relied on that, holding that the media should not only rely on freedom of expression, but it must also foster it, and the people's ability to function effectively in society depends on how the media fulfills its own obligations. The media are thus both right bearers and bearers of constitutional obligations. So, and then it goes on and then deals with McBride.
Yes.
And the point there, my lady, is that Section 16 is used opportunistically. Section 16 guarantees, yes, the freedom of the media, but it also guarantees the right of the citizen to receive accurate, to receive information. And you'll find that, my lady, in Section 16(1)(b). So Section 16 of the Constitution says, everyone has the right to freedom of expression, which includes freedom to receive and impart information or ideas. And my emphasis is on the freedom to receive. So just as the media has the right to impart information, the citizens have the right to receive information. And all I want, if you want to summarize my case, my lady, is to say, if you read that section together with the dictum by Klassen J, then what it means is that everyone has the right, when it comes to the SABC, everyone has the right to freedom of expression, which includes freedom to receive accurate, impartial, independent information. So the two things read together create a new Section 16(1)(b), which applies to the SABC. So that's the one thing. We've already made the point about that something that's exclusionary cannot be inclusionary, cannot be national unity. The third point, my lady, is that it's not disputed, let me put it that way, so that I don't attract the ire of my learned friend. It's not disputed what we say at paragraph 56 of our founding affidavit, where we say that the apparent motive of the ANC in its misdirection of the current political arrangements, or mischaracterization, I suppose, of the current political arrangements or coalitions as consisting of a government of national unity and the like, is to hoodwink its supporters and the public into failing to see that the ANC has entered into a politically suspect marriage of convenience with the DA and or the Freedom Front Plus. And we say, which still harbor anti-black racists and are vehemently opposed to key elements of the South African Constitution, particularly Section 9, which deals with measures to redress centuries of colonialism and apartheid. Section 10, which guarantees human dignity. Section 12, and to mention a few. Now, what is meant by that is that there's that's how I was saying we'll come to the ideological issues. Now, that you can call ideological, because what the applicants are saying here is that the hoodwinking was partly because there would have been no need if this was another revolutionary party, whatever that means. But the hoodwinking is exactly because the marriage is with people who are against the Constitution, particularly against affirmative action and BEE, which are measures to redress the injustices of the past, and people who, according to the deponents, still harbor anti-black racism. Now, if that is true, and this is not disputed, by the way, but if let's assume that is so, then how can you say a marriage with such people is a national unity? It can be, because it is the antithesis of what the Constitution stands for. It's the antithesis of the, I think it was in the interim Constitution, which called it, or Etienne Murenic, who is known to both of us, described the Constitution as a bridge to, literally a bridge from the bad past to the good future. Now, so you can't say something that is reminiscent of a step backwards to the other side of the bridge is that's what Obosiche was meaning when he said national unity is, or rather anything, conduct that undermines national unity is ipso facto undermining.
But surely, Mr. Mpofu, you're not asking this court to accept or reject the rhetoric in that statement.
No.
Whether they are anti-black movements.
No.
You're not asking that I accept that.
No, I ask you to accept only the following, because you have to, because it's common cause. That those parties that I mentioned are vehemently opposed to key elements of the South African Constitution, particularly Section 9, which deals with the measures to redress the effects of centuries of colonialism and apartheid.
So I must accept that?
Yes, because
as a starting point?
No, as a fact, because it's alleged as a fact and it's not disputed. So before you, that is a fact. Unless someone can come, I'm sure, and bring evidence that no, they accept affirmative action and so on.
Well, isn't that the same debate as whether it's unity or not?
No.
Are we not now
entering
into a debate that a court should not find itself?
No, my lady. No, with the greatest respect. There is something called the Bila Act, right? There are parties that oppose it, there are parties who support it. That's a fact. It's not colored by any emotion or feeling. It's a fact. And if I say in an affidavit, this party rejects the Bila bill, and it's not disputed, the court has no choice. It has to. So let's take the emotion out of this. It's a fact, a cold fact. It could be that they accept that Johannesburg is called Johannesburg, or it should be, maybe Tswana is a better example. There was that debate with the AfriForum as to whether it's called Tswana or it's called what. It's a fact if they reject it. So the court must not fall into this trap that because something pertains to politics, it's no longer a fact. So the ANC lost the election in May 2029. That's a fact. It's also a political statement, but it's a cold fact which you can put here. Okay. So now, so the allegation, as I say, is made there, and it's made not for political rhetoric. It's made to show what the hoodwinking or fig leaf thing, whatever it is was really all about. The only question I'm putting to your leadership is whether, if that statement is indeed reflects the reason why the fig leaf was made, can a court of law endorse such an anti-constitutional conduct which is motivated by this and say it's consistent with the Constitution?
Well, again, we're in a political arena.
Right. Okay, I'll leave it there.
Yes, thank you.
Yeah. Now, so the point of the matter is really this. For whatever reason, and that's why I like to go back to my religious analogy. If the debate between, there's that church that had people eating snakes or whatever, and if they call themselves the Anglican Church, and the Anglican Church says no, this is not, we can't be associated with this, and then but the SABC continues to call them that, then the Anglican Church is entitled to come to your leadership and say, we are aggrieved because our own dignity, personality, identity, in this case citizenship, rights to citizenship and rights to participate as a citizen, have been affronted.
But isn't that a passing off?
A what?
A passing off.
It might well be, but it's a grief. I'm not saying I'm not worried about the labels. I'm saying that those people are entitled to come here and enforce their legal rights, whether it's called a passing off or whether it's called an affront to their religious integrity. It's neither here nor there.
Yes.
The point of the matter is that the courts, you see, the courts are here to regulate the Constitution literally. In other words, if I say this conduct, as we say here, is inimical to our right to receive accurate information, independent information and so on, is inimical to our right to access information in terms of Section 32 of the Constitution, is inimical to our right of citizenship in terms of Section 20, and is inimical to our right to participate in the political activities of the country in terms of Section 19. Then the court must seriously look at that conduct that is alleged, and whether it has any adverse effect on those rights. As a cold thing, it doesn't matter which topic we're dealing with. And if the court finds that, as Ngobosiche says, that such conduct which may undermine unity, or that's not national, that's neither national nor unity, for it to be called that would offend the sensibilities. Remember, these are not just casual individuals. These are taxpayers.
Of course.
They are themselves, they own the SABC. They are the owners. They pay their license fees and all that. And they are saying, we cannot pay for our own abuse. We can't be abused by this institution that A, we own, but B, that we pay for. That's the difference between a private broadcaster and a public broadcaster.
No, I understand.
Yes.
I understand the contention.
Yes.
In relation to the responsibility.
Yes. And in relation to the issue of impartiality, in the UK, for example, everyone knows that the Guardian, the Observer, the Independent, those papers support the Labour Party. They, by and large, are regarded as left parties. Then that's fine. There's nothing wrong with that. But the day the BBC behaves as like the Guardian and takes sides in the political debate, then there will be a court of law like this. And if we don't appreciate that distinction, again, which is what Klassen J was saying, that a private broadcaster can do whatever they want. And it says a private citizen or broadcaster has the freedom of expression and so on.
But I think you've made that submission.
They freely take political sides and so on,
Yes.
which is what those newspapers would do. So unless, as I say, this would become just an academic debate if we don't appreciate that it's rooted in two things and two things only. The fact that we're talking about an organ of state which owes duties to citizens, particularly the 4 million citizens who are in a way directly or indirectly before you. And we're talking about a public service broadcaster which has those extra duties or extra limitations, quote unquote, to its freedom of expression. So rounding off, because I'm going to have another chance in reply, with the greatest respect, my lady, I'm not going to address in any much detail the issues of the alternative relief, save just to say that again, once again, the liberal accusation that says that the sections of the Constitution are just listed is wrong, because that means it's from someone who has not read the papers. Because you can't simply quote paragraph 49, which indeed lists the as I did to you at the beginning, lists the sections, but not read the rest of the affidavit under section E, analysis, which is where now we say how this independent accuracy and so on and so on. That's where that debate is. And then the section C, which is the factual matrix, which we have gone through. So you can't just nitpick one paragraph and say, you've just listed. You must read the affidavit as a whole, number one. Number two, another sign that either my learned friend did not, I would like to believe they didn't read the founding affidavit.
I'm sure Mr. Matau read the founding affidavit.
Well, then he didn't.
I know him to be.
Yeah.
I know him to be fastidious
Yeah.
in the manner in which
he was not fastidious. Yes. Then he was.
I know you.
Yes.
To be fastidious.
Of course.
Equally.
Yes, my lady. But in his fastidiousness, my lady, he forgot to read paragraph 82, 82.1, 82.2, 82.3, and 83 of the papers. Because they say in their papers that we have not asked, to the extent that internal remedies have not been exhausted, we have not asked for the exemption. The exemption which is in section 7.2c of PAJA. But here it says at 82, in the event that it becomes necessary to advocate in the alternative relief, the basis upon which the applicants are seeking to be exempted, the exact word in section 7.2c, from such internal remedies can be gleaned from the following propositions. And then we list the propositions. And then we even refer, the test in section 7.2c is exceptional circumstances and interests of justice. Then we say at 82. Ultimately, the interests of justice favor the bypassing of the purported internal remedies. The matter is truly exceptional as demonstrated by the salient facts contained in this affidavit. So if Mr. Matau had read this, then he would have said, these grounds are bad. But he's not allowed to say we did not do what we actually did here, because we did ask for the exemption, which is in section.
Well, he's going to get his turn.
No, whatever turn he gets, it will not change the fact that it's false to say that we did not ask for the exemption. Even if you can get 100 turns, it will. The fact is the fact. Yeah. So all I'm saying is that we did ask for the exemption, and the basis of the exemption was a simple one. It's something called, and I think we even refer to it, it's something called, at 83, we say, I'm advised the rule of convenience known as the once and for all rule applies to these circumstances. Now, colloquially, the once and for all rule says this. If, let's assume we are here, they don't contest that we are here from section 172. So the once and for all rule says, well, even if, strictly speaking, the court didn't have jurisdiction, we could bring that, because otherwise we have to bring this here and bring it there.
So it's a matter of convenience.
Of convenience, yes. It's called jurisdiction. There's a Latin term for it. But the point is that I can have a claim against you arising in Joburg and another one in Cape Town. But I don't have to go in Cape Town and Joburg. I can bring them together, even though, strictly speaking, the other one is. So that's the application. It's here in black and white. It can be wrapped out. Yeah. So it's either the court would grant such exemption if we get, as your Lordship said,
If we get there.
if we get there. The last point is that if we get to legality, which is even worse, because we would have to go past Paja, then clearly we say that it's irrational, because the conduct is not rationally connected to the mandate, to the powers of the SABC. So that's all I'm going to say on the alternative relief. But I'm
But you'll have the right of reply to
I-
the extent
yes.
that
No.
anything
It
arises that
yeah.
you feel you have to put right.
Yes, my lady. No, that's why I'm doing this so quickly, because I don't want it to be accused of raising it for the first time and reply.
Yes, of
So I'm
course.
making this point so that my learned friend can respond to them, and then of course I'll deal with them in reply.
Thank you.
Those are our
Right.
submissions, my lady. So we ask for the order in paragraph 2 of the notice of motion, and then paragraph 3, the just and equitable, and then the justifications for the punitive costs that we ask for are contained mainly in the replying affidavit. I also won't go much into that. I'm
Thank you.
indebted to your ladyship for the interesting engagement,
Yes.
and to having had the ear of the court on this very serious matter.
Thank you, Mr. Mpofu. And you're welcome.
As a cognizance.
My lady, let me start with the example that was raised later in the debate before I deal with the structure of the argument as a lead-in, because it will make issues quite simpler to follow and to engage with the discipline of legal pleadings. What is it that is expected of a party? What has been done and what has not been done? My lady, our learned friend gave an example about...
The question is, what is the cause of action?
Yes, precise. And what is the relief that you can ask for? Your ladyship, in response to the example that was given by my little friend about the eating of snakes and the Anglican Church coming up to court and its entitlement to raise constitutional complaints, your ladyship was spot on by asking the question, but is that not a passing off? Because if it is a passing off, that is the remedy that you seek. It doesn't in any manner, form or shape entitle one to constitutional remedy or reliefs. If there is a specific form of remedy that the law provides, which does not implicate and or breach the need for one to deal with the Constitution. And maybe that is an important principle, because your ladyship will see as we present our argument. What I intend to do in the argument is to first dispose of the alternative reliefs, which are review reliefs, just purely from a pleading perspective, just to indicate to your ladyship that there is no proper invocation of the principles that warrants your ladyship's attention to have to adjudicate whether is this a Paja review or is it a legality review. No case whatsoever has been made up in the papers. Then, my lady, I will thereafter focus on the constitutional relief.
On the 172 relief.
Yes, my lady.
Yes.
And equally indicate that if there is a remedy, even assuming in favor of the applicants, if there is evidence that there is a breach of the editorial code or the SABC charter, then, my lady, what a party seeks in court is that the SABC has breached policy X, Y, and Z. That's the remedy. The next layer will be, if there is a breach of the Broadcasting Act and a particular section that has been breached, that's what you come to court for. And that's what happened in FXI, which I'll deal with, lady, in detail during my argument. And the point there, my lady, is this. We've given our learned friends notice of the fact that we're going to be raising the question of subsidiarity. And your leadership is quite affair with that principle. Where there is legislation that is enacted to give effect to the provisions of the Constitution, a litigant is not entitled to bypass that legislation and try and find relief in the Constitution. That is impermissible. And it is for that reason that in FXI, that FXI sought the remedy that the SABC had breached its editorial code and had breached Section 10 of the Broadcasting Act, and that's the order that was granted by Glasinje. So it does not then entitle the party to go and seek a declaration of unconstitutionality under the rubric of 172, when there is legislation and/or instruments, which our learned friends characterized during his argument. He said these are constitutional instruments. And my lady, we have no quibble with that description. But the point about it is, from the discipline of what one can seek by way of a remedy, they have sought the wrong remedy. Even assuming they're correct on everything, the remedy is to say the SABC has breached its editorial code and these provisions, etc., and it has breached the conditions of the Broadcasting Act and these sections. There isn't such a case, my lady, and because there isn't, if you've asked for the wrong remedy in breach of the principle of subsidiarity, the court unfortunately cannot come to your assistance. My lady, if I can just ask then that we just do the exercise of dissecting the founding affidavit, because once we do that, your ladyship will see that many of these points that our learned friends make, they are only superficially attractive. But the conclusions that are being sought to be drawn from that are not the conclusions that are legally sustainable, through which the leadership can come to the assistance of the applicants. So, my lady, it's a fascinating political debate at best. But with regard to the principles of pleadings, the competence of remedy, and the discipline that one must follow, none of that has been observed. And for that reason, my lady, the claim is not only one which is not of a constitutional nature, which would necessarily, on the facts of this case, as we will demonstrate, it would warrant that costs be awarded against the applicants, because this matter has got nothing to do with the Constitution. And as the authorities say in the Constitutional Court, which we've cited, a matter that is purely factual, which is dressed in constitutional garb, is not a constitutional matter. It's just a factual issue. And what would be a factual issue here? Assume on the three pillars that our learned friend has argued, on inaccuracy, on impartiality, and on independence. Those would be standards that are set out in the SABC Charter and the SABC editorial policy. If there is a breach there, that's the relief that you seek. If it's buttressed through the Broadcasting Act, that's the relief that you seek. It's got nothing to do with the Constitution. And it's important because when we get to the BioWatch debate, or at least submissions on it, because there shouldn't be much of a debate with reference to the other decisions of the Constitutional Court that we've cited, Mahlangu, etc. The leadership will see that the applicants cannot find refuge in the BioWatch principle. So, my lady, to do so, might I just ask, my lady, we know if one has regard to the notice of motion, and if I can just ask your leadership to walk this journey with me, and your leadership will then immediately see the point that we're making. We know that the primary relief that the applicants seek is the one that is set out in prayer 2 of the notice of motion, which your leadership will find on page 02-55. So the 544. And that's the declarator. So that is what we will label, for purposes of our submissions, the constitutional relief.
Yes.
And then in prayer 3, granting just and equitable remedies in terms of section 172(1)(b) of the Constitution, including the immediate dissemination of this order. We call that the dissemination relief. And my lady, in prayer 4, there is, in the alternative, an order that is sought, or a prayer that is sought, that your ladyship should grant a review and a set aside of the SABC's decision, i.e. in refusing to accede to the letter of demand under the principle of PAJA, alternatively through the principle of legality. So that we call the review relief. So we have 4 reliefs: constitutional, dissemination, and review relief. Let me call them 3. Then, my lady.
Well, the one is hand in hand with the second is hand in hand with the first.
Yes, my lady. In the papers about dissemination, why it's necessary, why it's justified in the circumstances, etc. So that becomes the easiest. There are no facts whatsoever. It's just mentioned in the notice of motion that is being sought. There are no allegations in support of that. So,
but I can fashion my own relief.
Yes.
Should I feel that I need to do that? There's nothing that stops me from doing that.
Your ladyship is quite familiar with these principles. I mean, we've debated in the context of procurement matters the import of Section 172 and Section 81C of PAJA, and all pay, for example, my lady, where if an issue that your ladyship is minded to consider for purposes of fashioning a remedy occupies your ladyship's mind, your ladyship would say to the parties, address me on this and this, why can't I grant A, B, and C? But on things as they stand, there's absolutely no fact.
I would have to, you say, I would have to make acceptances of certain principles.
Otherwise,
I would have to,
because it doesn't arise in the papers. There are no facts that support it.
I would have to take judicial notice. That's what.
Yes. Alternatively, my lady, as the courts do, if you are minded to fashion a remedy where there are no facts that arise, your ladyship would give a directive to say, I need the parties to address me on A, B, and C, because I want to know whether it would be competent to do 1 or 2 or 3. That your ladyship is entitled to do. But what your ladyship can't do is, of course, when there is no factual foundation in the papers and without affording the parties an opportunity to have a say in terms of a just and equitable remedy, use 172 as a license to fashion anything and everything, even that which was not placed to the parties, for the parties to at least make submissions to your ladyship on why this would be competent and why that would be competent, etc., etc. It's just a broad all-pay principle, if your ladyship recalls all-pay 1 and 2.
Yes, I do.
So then, my lady, in respect of the review relief, we say 2 things. And if I can just ask your ladyship to turn to paragraph 74 to 76 of the founding affidavit, commencing at page 02-748.
You want me to turn it up?
Lady, I can just give your ladyship the reference and
Yes. But if you want me to go there, then I'll go there.
perhaps, my lady, it might be easier to navigate this through walking this journey together.
All right. Just give me that that page again.
It's
then,
page
please.
02-748. Commencing from paragraph 74.
Yes, thank you.
What your ladyship finds there is under section E2. The applicant tells your ladyship that they seek relief in the alternative, and that's what we called earlier or described as the review relief.
Yes.
And they tell your ladyship that that relief is based on PAJA, and more specifically, and what follows thereafter is a listing of the PAJA grounds that are enumerated in section 6(2) of the Act. And in section 76, what they then say is these legal conclusions are squarely based on the factual matrix described in section C above, I'm advised that further elaboration will be provided during legal argument. My lady, this is what we say is patently defective. Because it is not permissible for a party to plead a case in this manner. The discipline in motion proceedings, as your ladyship would know, it is by no means different from a witness that is giving evidence. But in this instance, there is no engagement to say which facts that are set out in section C implicate which section of PAJA. In other words, how is the conduct, the impugned conduct, implicated by which fact in section C? And how does that connect to which section of PAJA?
Well, there's one theme, if I can put it. There's one theme, if I can put it thus.
Yes.
The conduct is that the SABC refers to the alliance or the whatever it is.
Yes, the arrangement.
The arrangement refers to it as a government of national unity. And says Mr. Mpofu, it may not do that because it's more than a name. It's not a question of that is its name. It's it should take cognizance of the fact that there's a political debate in relation to the use of this term, and it should not use it. That's the simple. That's the simple constitution.
Factual narrative.
And that, yes, that's
or the factual construct.
That's the fact. Those are the facts. And there's it goes a bit further in relation to the fact that it's obligation and right based, but ultimately therein lies the crux, as I see it.
My lady, the factual. Sorry, my lady, am I not interrupting you, lady?
Not at all. No.
My lady, I'm addressing a slightly different point from a pleadings perspective.
Yes.
It is one thing to set out a factual construct or a factual narrative. It is quite another to say these facts implicate this section in this way. In other words, the impugned conduct is in breach of section. Let me give your ladyship an example. Let's go to section 75.4 of the founding affidavit. If your ladyship can read it with me.
Yes.
Section 62G, in that it consisted of a failure to take a decision.
Yes. Well, a decision on their own version was taken against.
But that's the problem, my lady. This eliminates the problem. You can't plead in this way. Because what they then say is, we will tell you in legal argument in 76 how all of this connects together. You can't plead to such a case. You can't.
What is that case? I'm sorry, it's gone out of my head. That says just that. That says you may not. You have to be more specific in your pleading.
You have it in Swissbro.
Swissbro.
And you have it in Leipzig.
Thank you.
Justice Joffrey in Swissbro. That's a principle because, and your ladyship will recall, Justice Joffrey even says in analyzing 6.2, you can't just attach papers or an attachment without specifying which portions of the attachment you are relying upon for purposes of your case. So that's kitchen sink, and you say, well, I'll tell you in legal argument. How does one plead to that case? It's impossible, my lady. And
so, in other words, you're taking an exception.
No, my lady, it's not even an exception.
Well, of the nature of
my lady, we had this debate.
You say it's vague and embarrassing.
My lady, we had this very debate not so long ago, and I'm going to refer your ladyship to the Mkhwebane judgment, where the very same criticism was raised and the argument was upheld. Because you can't just bring a case that is non-specific. And one of
I have the submission.
Yes, my lady, and one of the issues that arises, perhaps I might just deal with it here so that I don't have to go back to it. when we get to the Mkhwebane judgment, I'll just give you leadership the references. But one of the problems that arose there is, if you say, even if you get past that problem of lack of specificity, if you say this is Paja, you need to engage the 7 steps that are prescribed in the Motau decision. And I'll give you leadership that reference.
It's in your heads.
Yes, my lady.
Yes.
The Motau decision is in our heads, but we make, in the heads we make the point that it is adjunct to a policy as described in Motau. So we make a different point with reference to that judgment, but it is also good law for purposes of this point that we're raising. So I'll give you leadership the relevant paragraph.
You only have to give me the references if they're not in your heads.
Yes. That particular paragraph is not in our heads. So, my lady, this should be sufficient given the time that we have, just to illustrate one of the difficulties that arises. Because imagine if your ladyship was pleading to this. Your ladyship would have had to look at the section C, that sets out the factual matrix, and then look at this and look at 75.4, for example, and say, well, do I plead to this, do I not? And if your ladyship does, your ladyship might still get it wrong, because the applicant has said in 76, I'll tell you in argument, I'm not pleading it. They're kitchen sink. That's the difficulty, my lady, with that form of pleading. It's not allowed in our law. So that, my lady, should indicate the lack of specificity in the Paja case, insofar as that part of the cause of action in the alternative, if we do get there, my lady, for purposes of determination, your ladyship will see that there are factual and legal hurdles to the competent granting of that order that is sought. Then, my lady, perhaps while I'm here, I might also just deal with the alternative, the failure to exhaust internal remedies point. And this point arises in this manner.
Goes hand in hand with your last submission, because there has to be an exceptional set of circumstances. Mr.
Yes, but also
makes that submission himself.
Yes.
And you say, to the extent that that set of circumstances is taken into account, it must be pleaded.
The discipline, and the decision that we've cited, Tenge, there is one in this division where Justice, the DJP, Justice Sutherland, also upheld the issue of a failure to exhaust internal remedies. But let me not go there. Let me just deal with Tenge and these cases. You then bring an application in terms of Section 7.2 of Paja, requesting to be exempted. Because Paja then tells you that this is the discipline. You can't throw it just in the air and say, well, if we get there, this is what we're asking for. And the last point we make, and this is why, Lady, you need to invoke it properly. Your ladyship knows the once and for all rule is a cause of action issue. It's not a jurisdiction issue. You can't say because I have 2 different causes of actions that arises in 2 different courts, through the once and for all rule, I can found a court's jurisdiction. That becomes a consolidation issue.
It's a causa continentia or something they call it. Yes.
Causa convenience.
Yeah.
Yeah.
Yes, but lady, that becomes it's not a once and for all rule, because that's a criteria that you must satisfy. When you apply for a consolidation, there may or may not be benefits, etc., etc., etc. But the once and for all rule in this instance does not, in circumstances where the issue, as you say, implicates the editorial code. It implicates the SABC's charter, where those instruments have got internal remedies themselves. And you simply then say, well, I'm going to bypass them under the once and for all rule, which is intended to regulate something entirely different. Because you would say why it's convenient, etc. And the SABC would set it out, as it did in its response to the letter of demand in MK8, which your ladyship finds, just your ladyship does not need to go there. The note is 02549, where they say there are two steps. It's the internal one, and the second one you go to the BCCSA. And this is important, my lady, because there is no constitutional issue that arises, and that's the point, which I'll illustrate when I get to the constitutional relief with reference to the subsidiarity principle. So that's why you plead those facts, and you bring that application as part of your remedy. But my lady, the debate might just be interesting, but we say, on first principles, the case does not get out of the starting blocks as a Paja review from the deficiency of the pleadings. So that's where we submit the case should end. Then, my lady, we then have the legality review, which is also equally easier to dispose with reference to paragraph 77. In paragraph 77 of the founding affidavit, they say the review ground is also based on the alternative ground of a breach of the principle of legality, to the extent that the impugned decision is plainly irrational in the circumstances. That's all. That's a legal conclusion. There are no facts. So you'll have to do the same thing. Why is it irrational? And the SABC pleads in the abstract that it says that, well, this is rationally connected to the purpose that is sought to be achieved. Because the SABC says, all that has happened is we're referring to the government the way it calls itself. We've made the platform available. Our viewers know that we've invited commentators, even political leaders. You've been told one of them, Mr. Malema, has also been hosted, who've expressed different views that this term is politically controversial and parties or political parties don't make common cause on its appropriateness for purposes of usage. But importantly, the SABC says we are not an arbiter of the correctness or otherwise of the usage of the term. We just say this is what the government calls itself. No more, no less. We don't endorse the correct usage of the term, and we don't say it is correct. And which is what your ladyship raised with our learned friend, that accuracy is one thing, but this is a politically contested term. And my lady, let me illustrate with reference to...
Do you say it's not for this court to enter into that arena?
Absolutely not. But importantly, the SABC says the decision to continue in compliance with the injunction in the editorial policy to represent or at least to broadcast a plurality of views includes highlighting the fact that this term is politically controversial, political parties are not in agreement, and to give the platform, which is what the SABC has done, for those who are pro and those who are against. And this is one example that is cited by the applicants themselves in the founding affidavit, which is the irony of the case. Sorry, I thought I'm being given an instruction. I could hear a voice from the back. So, my lady, once the SABC in express terms says we are not an arbiter, we are not endorsing, no mimicking arises, my lady. No parroting arises, because they say this is what the government calls itself. Here's the political debate about it. And my lady, this point that this is a political issue which morphed into a legal issue at some stage is exposed by the letter of demand. Might I just ask your ladyship to go to the applicant's letter of demand, which is MK7, commencing from page 02863, so that your ladyship will see that the national broadcaster is sought to be used for purposes of pursuing political debates. Your ladyship can go to 02864 over the page. Paragraph 3, my lady, that's where I'll ask your ladyship to start if your ladyship has it.
Yes, I have it.
The reference is made to the terms by the SABC itself. And this is in the context of what they're saying, GNU and PNU. Via its employees constitute multiple and repeated breaches of the independence and related public mandate in terms of the SABC editorial policies read with the Broadcasting Charter, the Broadcasting Act, and or the Constitution. More specifically, these provisions enjoin the SABC to report accurately and impartially, independently of political or commercial powers and influences. Then over the page, please. Paragraph 4. You are no doubt aware our clients stated the following during a recent public address to the nation, which was covered live by the SABC. Importantly, as a platform, the SABC affords the utterer of these words, Mr. Zuma, a platform to express his view on the term. And this is what he does. He uses that platform to express the following. Regarding the current political situation, we need to educate our people that there is no government of national unity in South Africa. There is wide-led unholy alliance between the DA and the ANC of Ramaphosa. It is sponsored by big business. It is for the benefit of the markets, not for the people. Then, 3 things, my lady, that we wish your leadership to note. 1, it must be crushed before it finds its feet. So this is a political contestation to crush this arrangement before it finds its feet. The media is also selling the story of a GNU when they know that there is no such thing. I know because I was part of the leadership which introduced a GNU in 1994. We've asked our lawyers to write a letter to the SABC to stop deliberately misleading the South African by using terms like government of national unity or government of provincial unity. Here's the second point. Refer to the present sell-out collisions. That is a political posture that is taken by the utterer of the words.
Well, it's rhetoric. It's political rhetoric.
It's political rhetoric, precisely.
As I said to Mr. Mpofu.
Precisely. And then the last thing...
It takes a particular side.
Stance from a political perspective to say, to us, this is what this term means. There is nothing, or this is nothing but a return of apartheid and colonialism. And lady, there is nothing legal about this point. This is the issue that we're raising. It's all founded on a political complaint. So these are the 3 elements that arise. My lady, and then if I can just deal with the second unnumbered paragraph and I'll stop. We know that the private media has to serve its masters, but the SABC belongs to us. It has no right to feed our people with lies and to pursue narrow agendas at our expense. We shall seek an urgent meeting with the SABC board and management to raise this issue and, if necessary, educate them, and hear the following words, on the correct political terms which are appropriate. So there, you have confirmation. The attack is premised on a political rhetoric, and the issue is the SABC is using an incorrect political term. And
but I'm sorry to interpose. But, says Mr. Mpofu, in the same way, wound up in this term is also rhetoric.
No.
And the fact that it is used suggests that rhetoric is rejected, and the rhetoric contained in the GNU is accepted.
No, we understand that that's the argument.
That's the argument.
Yes, no, but my lady, we are showing that firstly the genesis of it is a political contestation. But the second aspect is, what does the SABC then do? Because that's the nub of this case. if the SABC had expressed a view that in broadcasting and or referring to the government as it refers to itself, the government is correctly employing the term, one, and that the SABC endorses it in those terms, then that is where taking of political sides is involved, and that is why I'm gonna go to FXI, because the SABC will then be taking sides. And two, if the SABC was suppressing all views on the subject, then Malidi, that would be a breach of the editorial code and the policies, and that's the upshot of the case. And let me give an example here, which is aligned to the Catholic Church example that Mr. Mpofu used. We know at the moment there is contestation between the African National Congress and the MK Party regarding the latter's entitlement to call itself the MK Party, the SABC. So the ANC says, this is our legacy, this is us, etc., etc. There is that debate that is playing itself out in the court.
That's a passing off question.
And this is the point. When the SABC reports, it calls the MK Party the MK Party. It doesn't say it's the so-called MK Party because the ANC is currently in a dispute in court, and whether the MK Party is entitled to call itself. So, and in referring to it as the MK Party, the SABC doesn't say the adoption of the term of the name by the MK Party is correct, and therefore we endorse it as the MK Party.
So you say mere statement of what a party calls itself does not without more does not represent endorsement. And you say to the extent that more was added, like so-called, that too could be construed as a taking of the side. So it's damned if it does and it's damned if it doesn't. And you say it's not for the court to tell it how it should entertain what everybody accepts is a political debate. Does that sum up what
your ladyship anticipated the submission? Correct.
Yes.
Because I was going to go to the flip side to say that presents a very problem, because the others would have said, well, you've taken a stance because these ones are calling it this. So the SABC hasn't, and the SABC's position is clear to all of these people. The SABC, even through these proceedings that are being published or broadcast, the SABC's point is clear, even on affidavit. It does not endorse the GNU and its usage as the correct political term. It does no such thing. And it tells its viewers and presents a balanced view, which includes a plurality of views as it is required to by the editorial code and the policy, to say it is a politically controversial term. There is a contestation. Here is a platform. And Milady, might I, on that note, go to FXI?
Yes.
Just to remind ourselves what FXI was about, and to show your ladyship that what this applicant 6 is actually the same as what.
I think you've given me the case, haven't you?
Yes, my lady, I have. Let me.
Oh, it's in Mr. Mpofu's client's bundle.
Yes, it's the class and J one.
It's the class and J one.
Yes, my lady. Let me just find it quickly. Yes, I've got it. We both parties refer to it, my lady.
Yes.
Our learned friends have it at 19-186.
Yes.
Lady, just for your ladyship's notation, we have it at 02-122. And that one has a citation. It's 2011 JDR 0036.
Just give me the number again. Sorry.
It's 02-122.
Thank you. Yes.
So, my lady, let's remind ourselves what FXI was about. And your ladyship will no doubt have regard to it because of the fact that the applicants seek to rely on it heavily. What had happened there, my lady, it was about the coverage of the Zimbabwe elections. And the then head of SABC News, Mr. Snuki Zigala, had pronounced and prohibited the publication or the broadcast of certain information regarding the Zimbabwe elections, and had also blacklisted certain commentators that are listed in the judgment. And I'll give you leadership the paragraphs. Mr. John Pellman and others, and his colleagues who were SABC employees at the time, wrote a letter to their then CEO, Mr. Mpofu, to alert him. Well, it's all in the judgment. It's good. It is all in the judgment. Well, unlike what our learned friend did earlier to testify from the bar about personal knowledge, in this case, I'm not relying on his personal knowledge. I'm relying on the judgment itself. What then happened is the CEO appointed a commission of inquiry, what became the Sisulu Commission of Inquiry.
Yes.
And the Sisulu Commission of Inquiry upheld the complaint, or the complaints. And a report was produced. The SABC did not disclose the report. That was one of the controversies. Your ladyship will recall, the Maiden Guardian published a version of that report. I'm doing all of this just to save time. The FXI then brought a complaint to the CCC, the compliance. The CCC of ICASAS. The Complaints and Compliance Committee. Sorry, the name had escaped me. And what then happened is the CCC ruled that it did not have jurisdiction to adjudicate that complaint. And faced with that judgment, FXI then brought a review, and specifically it brought a PAJA review on the basis that the SABC's conduct, which was to suppress information and to mimic the position that was taken by the government of the day, as it were, in relation to Zimbabwe, had breached, in doing so, it had breached its editorial code and had breached Section 10 of the Broadcasting Act.
Do you think that this may be an opportune time?
Sorry,
I see that it's 1 o'clock. Shall we come back at 2 o'clock?
yes, that's in order, lady. Yes, we're happy.
You wanted to say something?
No, it's fine, my lady. I wanted to know if my learned friend was not inclined to ask the court to come a bit earlier, if it's possible. but depends on whether the court is...
What do you think? Do you think that shall I come 15 minutes early? Shall I sit until 1:45?
Please.
It'll give us that
Yes,
last
after
15
As
minutes.
a court please, my lady. My lady, while I'm on my feet, I just didn't want to interrupt my learned friend. He made a reference to having given us notice that they were going to raise the issue of subsidiarity.
Yes.
So because I didn't want to interrupt him, I asked his junior, but I've not been able to get that. So maybe he can...
Well, you'll do that during
the
you'll do that during the adjournment.
Yes,
then.
yes, my lady. And okay, there was something else, but I'll raise it. If I remember, I'll raise it before he starts, so that I don't interrupt his flow of argument. That's good.
Sorry, how long? Just to avoid...
I'm just going to take... I'm going to come back at 1:45.
Thank you, my lady.
That's good. I'm indebted to you.
Yes. The court will adjourn until 1:45.
No, they don't.
When?
Yes, Mr. Matar, are you ready?
Thank you, my lady. Before the adjournment, I was dealing with
Yes.
and what the case was about.
Yes.
My lady, might I ask your ladyship to look at paragraph 69 of that judgment?
Yes.
It's on page 19-213.
Paragraph what?
69.
69. Yes.
And my lady, that gives your ladyship the parameters of the debate before your brother Klassen in that matter.
Yes.
So it's an allegation of the transgression of the license condition and section 10. There's an argument that was never persisted with, that's at 70. So paragraph 70.
So these are the two.
These are the two.
These are the 2 points
And-
raised.
Then my lady, if I can then ask your ladyship to tend to paragraph 52. Of that judgment.
Yes.
Your ladyship will see what a part of what was in issue there was the SABC's dishonest cover-up under that heading. And I've referred to some of the issues. But if I can just ask your ladyship, just for purposes of emphasis, to look at paragraph 54.
Yes.
later that same day, this is after they wrote a letter to their then CEO. The one by Mr. Pellman and his colleagues that I referred to earlier. Later the same day, the SABC issued a public statement in response to the Sowetan article. Mr. Pellman says that the facts in the statement must have come from the SABC's news management headed by Dr. Zikalala. The statement was a patently dishonest cover-up or attempt to cover up the truth. Dealing with each of the paragraphs of the media statement, the comments that follow upon each subparagraph are, in my view, quite justified. Then I only want to focus on 54.1,
Yes.
which was that media statement. The SABC would like to state that the news division has not imposed any blanket bans on the use of individual commentators by our current affairs programs as reported by the Sowetan today. Mr. Pellman says that this statement was blatantly false and a deliberate attempt to mislead the South African public on an issue of critical importance. That was indeed so. Dr. Zikalala had by then blacklisted many individual commentators, including, and those commentators are listed there. Then if I can ask your ladyship to turn to the next page, 54.4. The SABC subscribes to freedom of speech in its policies, and we strive to give the South African public a diversity of opinions and voices on any topic discussed. This was a rather cynical distortion of the true facts in light of a false cover-up of Dr. Zikalala's blacklisting. Now, two things emerge from that. To prove that in this case, the conduct of the SABC is the opposite of what it was accused of. If one has regard to 54.4, the SABC, in the exercise of its freedom of speech, as enumerated in its policies, strives to give the South African public a diversity of opinions and voices on any topic discussed. And what is the topic in this instance? The topic is the GNU. And the SABC, there is no cover-up, there is no taking of political sides, but it presents the facts as they are. And which is why, my lady, that's the context in which the remarks by His Lordship Justice Klassen in paragraph 77 of that judgment and that footnote should be understood. So, having regard to what is an issue, remember the complaints by the journalists reporting to the CEO, a media statement that is issued which is false, it does not accord with what was reported to the CEO, a commission of inquiry, its report is suppressed and not disclosed, and there is a blanket ban on commentators who would comment critically about the Zimbabwean situation. And so that the point that we are proving is there was suppression. Here you have a compliance with the very duty that Klassen J references in paragraph 54.4 when it quotes and says those complaints were justified. Then leads to paragraph 77. The SABC cannot be equated with a private citizen or broadcaster who is simply entitled to freedom of speech. And that footnote, my lady, is important. See the SABC policy, news, current affairs and information, paragraph 1 on page 499 of the record, where the following is stated. The SABC occupies a distinctive position of trust in the lives of its viewers and listeners. We are the most extensive, all-inclusive and diverse news organization in South Africa. The SABC considers it a duty to provide consistent, relevant, useful and top-quality information and analysis on which all South Africans can rely as they discuss and deliberate, form opinions and build a common future. Then returning to the paragraph, the SABC is a public broadcaster funded by the taxpayers and to provide the highest standard of journalism, which is fair, unbiased, impartial and independent news coverage. Whereas a private broadcaster might be free to take political sides and promote party political objectives. a political broadcaster may not use public funds to do it. So this, if one juxtaposes it with the facts in Kasu, it actually indicates that the SABC has learned its lesson from this judgment. And it does the exact opposite of the conduct that it was accused of on the facts of what was before His Lordship Justice Classen in the FXI matter. And it is for that reason, lady, that the SABC invokes the principles of freedom of expression as outlined by the cases in our heads. The duty of a broadcaster in the exercise of its freedom of speech and the right expressed in Section 16, it is to impart knowledge, to inform the issue of public opinion, not to blacklist any views that does not accord with the view that the SABC holds and or is sponsoring, but to put all facts at the disposal of the viewer so that viewers can form an opinion as to whether, according to them, it is or it isn't a GNU. But to do so in circumstances where the SABC makes it plain itself that it is merely conveying what is in the public domain, but endorses, so does not rather endorse. I meant to say it endorses neither of the contentions that are advanced by the political parties that hold opposing views on the subject matter.
Is this truly a freedom of expression issue? Is it really a freedom of expression? Because as I understand your argument, you say they're not expressing anything. They are attempting to, in the manner in which they go about their reporting, they call the coalition by its name, its given name,
yes,
and they take no issue either way. So it's not as if it's expressing itself, and that it has the freedom to express itself in one or another way. I don't see this as a freedom of expression issue at all.
No, my lady, we agree with your ladyship. In fact, your ladyship would have seen the case is being posited on two levels. The one is it's a factual issue. The policies of the SABC requires of the SABC to do this. It has done that. To insist that the SABC must accede to the demand would amount to an infringement of its editorial independence. That's at the factual level. That's the beginning and the end of a case.
But it's not a freedom of expression
well, yes,
case.
I'm going to come to the next level. Then the SABC says, to the extent that there is any issue beyond the answer that it has provided, which is a full answer to the facts, and if you get to the constitutional realm, then you are in 16 from an SABC perspective that in any event, as a broadcaster, the media has these duties and those are set out. But we accept, my lady, that at first principles, you don't even get to freedom of expression at all.
Because you say there's no expression at all. It's a name calling, and that is how we report it.
Nothing more.
And to the extent the example I put to Mr. Mpofu earlier,
Yes.
to the extent that there was a dispute around the Communist Party and whether they were truly communist in their manifesto or not. In calling the Communist Party, the SABC could not be said to be taking making a stake in that political debate. And you say as long as the debate is freely had and accommodated, which you say is the case, there's no suppression. Do I understand the argument?
My lady, your ladyship has summarized the argument correctly.
Thank you.
Then, my lady, para 98 of the judgment, this is the finding of by His Lordship Justice Klassen. He finds that the SABC's conduct clearly violated both the license provisions as well as Section 10(1)(d) of the Broadcasting Act, and he sets out. Then following that finding, he reviewed and set aside the decision of the CCC, which your ladyship will recall. The CCC said it doesn't have jurisdiction.
Yes.
And then he remitted the matter back to the CCC for reconsideration. So this is important, my lady, because of the very point that we've had now, or the exchange that we've had with the ladyship, where the ladyship says it's purely a factual issue, nothing more, nothing less. And if there was any complaint at all, the complaint...
Well, that's your argument.
Yes.
That's your argument. Mr. Mpofu's argument is it's much, much more.
No, sure.
Because GNU represents something that contains rhetoric. That's that's where the debate rests, the kernel of the debate.
And yes, and then the question is, well, what are the duties and the responsibilities of the SABC in that instance?
Yes.
And even without assuming, or at least without accepting that the argument would be correct, but assuming that our learned friends would be were correct in that argument, and I'm going to deal with the founding affidavit next. The issue would then be a breach of the editorial policies or the SABC charter. It's not a constitutional issue. So in any event, they haven't sought the right relief. So it's a debate that is fascinating, as I had said earlier, but it takes them nowhere. Because your ladyship will have to find what is it that I'm being asked to do here. And we are giving you this example in the Judge Klassen case to fortify the submission that you don't, by virtue of breaching the internal policies and the Broadcasting Act, which the applicants invoke, albeit inaptly. The upshot of that case, if they were correct, this is where the case would stop, or would have needed to stop. In other words, your ladyship would have had to be asked to say, this is the editorial code, this is what it prescribes, this is the conduct of the SABC, and it fell short of the standard prescribed by the code or the charter, and therefore we seek a declarature that in doing X or in refusing to do X, the SABC acted unlawfully, etc., etc. You don't.
Well, let's take Mr. Mpofu's example.
Yes.
The terrorist freedom fighter example.
Yes.
Now this is an international example in the sense that certain news agencies report that Hamas is a terrorist organization, and certain report that it is not. It depends on what you accept. Now, his argument is, but the GNU, it's a loaded term in the same way terrorist, murderer, these are loaded terms, and you've got to be careful about how you use them. So that's, as I understand, the gravamen of the argument.
No, we understand that. But that, my lady, with respect, it ignores the fact that as part of its duties as a broadcaster, the SABC presents all facts and all sides to the debate. Let's put it, to use that example of Hamas. If there was one view in the contestation, and the SABC were to say it will only present a particular view that is held by a particular sector, and suppress and not put the other side. In other words, including the fact that the usage of that particular term is a contested issue, then that would amount to a breach. So in other words, more is needed. When you've just said Justice Fisher, but there's a debate whether Justice Fisher was actually properly appointed, did she have a matric, did she not have a matric, etc., etc. She is Justice Fisher. And then you would report that, but there is a contestation whether she is or she isn't. Lady, it's an absurd example. I'm trying to find the most absurdest of examples just to show how absurd the case is.
Well, an example may be the use of the term doctor, for example.
Yes.
The title, professor, doctor, whether somebody can be called that or whether somebody can't be called that.
Yes.
Because it's subsequently discovered that the person doesn't in fact have the doctorate. What is then to be done when there has been a reference to Dr. X all along, and now suddenly there's a discovery that that is not the case? Do you revert to Mr.? What do you do? Or if there's a dispute in relation to whether there has been a doctorate or, conferred or not conferred, what do you do with that? What do you do with
Yes,
that title?
scenario. Yes. Your Ladyship postulates two examples to me. The first example is the title was used. It is subsequently found that there was no PhD.
Yes.
And let me take that before I deal with the second example. If there is a finding that says so and so is not a doctor, to continue to refer to them as a doctor would infringe, I'm assuming notionally.
But would that be a legal finding?
No,
would
no.
that be or would that be a factual finding?
But that's
Somebody says
well,
this politician calls himself a doctor, but he doesn't have a PhD, and there's a factual dispute about that. If there wasn't a factual dispute, and everybody agreed that indeed he had misrepresented his qualifications, well then it would not be permissible to refer to him. But to the extent that there was some debate in relation to whether the conferral of the PhD was proper or dishonest, would the continued use of the honorific doctor, would that then
infringe.
be allowed, or would it infringe?
Lady, the submission that I was going to make earlier on, and your Ladyship, and let me move to the postulation where we are. The duty of the SABC would be twofold. And let me start with the second one and get to the first. The second of those duties would be for the SABC to present to its viewers the fact that there is a controversy regarding the appropriateness or otherwise of the usage of this title. And this is a controversy that relates to, let's take for example, the one that arose in this country, Dr. Paulo Jordan. Now, if in reporting, the SABC explains the fact that there is this controversy that exists in relation to Dr. Paulo Jordan's qualification. In calling him that, Dr. Paulo Jordan, you haven't infringed anything. But there is this debate about it, and as the applicants are saying in their papers, there are court proceedings that they've instituted against the parties to the GNU.
Yes.
And the jury is still out on whether they are correct to call themselves that, or they are not correct to call themselves that, or they are allowed to exclude or not to exclude. That debate is unfolding parallel to these proceedings. We know the first round, a court has pronounced itself on some aspect of that. But that's not so much of an issue for your Ladyship, but for the following, that if the SABC would have suppressed the fact that the usage of the term GNU is controversial, it is contested, and there are legal proceedings. And if you were to say you can't mention those facts as part of the broadcast, so you are going to refer to it as the GNU, and beyond that say that the usage of the term is correct, which was the situation in FXI. Because in FXI, there was the question of whether it was appropriate to report certain things about the elections in Zimbabwe, and whether there had been free and fairness, etc., etc. And the suppression there was, we don't want to hear anything about any unfairness, etc., etc. So that's a blanket prohibition, and that is what infringes the codes and the prescripts. But to merely say that, for example, if there was no suppression on the Zimbabwe issue and people were referring to the ZANU-PF government or whatever it was calling itself, as a fact, that's what there is. But the fact that it is contested and that there are court proceedings, etc., etc., in so doing, you are complying with the entirety of the duties that are prescribed or bestowed upon you as a public broadcaster. Let me limit it to this because that's what the case is about.
Yes.
So there is, the opposite would have been the breach, and your ladyship earlier on anticipated the point that if the SABC had said as its usage, each time it was reporting the so-called, this, there would have been a problem. The opposite would have been the case. But the SAPC reports the facts neutrally. And on affidavit, it tells your ladyship, we are not an arbiter on the correct usage of this term. But there is a debate about it. Some commentators say, yes, there is a national crisis. It's all set out in the answering affidavit. There is unemployment, etc., 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 etc. That is the national crisis, and it does fit. It's not, but that's. Perhaps they'll have that debate in those court proceedings that are ensuing. But the SABC has done none of this. It has said the term is contested, and all that it does is it calls the government what it calls itself. Different is the case, my lady. And for example, our learned friend referred to the McBride judgment that they gave us this morning. Can I just ask your ladyship to have regard to the following paragraphs in that judgment? Your ladyship does not. Oh, well, you can go on, my lady, to paragraph 75. So I forgot it's the hard copy. And your ladyship would recall that was the issue about whether he could still be referred to as a murderer when there was an expungement following the national, following the applicable act. Let me call it.
Yes, yes.
Let me call it that. Lady, from paragraph 75, your ladyship, I can just ask your ladyship to note 75 to 78.
Yes.
But in 78, to summarize, there are at least 4 reasons why Mr. McBride's argument cannot prevail. First, it depends on a literal and a contextual approach which runs counter to the decision in Dudoy. Second, it is inimical to truth-telling, which was one of the moral bases of the transition from injustice of apartheid to democracy and constitutionalism. It is hardly conceivable that a statute premised on the necessity of truth-telling in pursuit of national unity and reconciliation should operate so as to render the truth false. Third, the interpretation fails to give weight to the right of freedom of expression. Fourth, it overreaches the benefits Mr. McBride earned when he sought and was granted amnesty. It would disturb the delicate interplay of benefit and disadvantage the statute reflects, thereby also creating an untenable anomaly in that only those convicted but not those never charged would gain immunity from truthful description of their deeds. So this part of the claim failed. Your leadership asked what was the order. It was important because it is in that context that the referral of Mr. McBride as a murderer, that part of the appeal, it failed because of these
issues. So the comment made is, well, it may be in bad taste,
but as a matter of fact. So But I'm just saying that it's not helpful for purpose of resolving your ladyship's debate. So
Yes.
so its invocation is entirely inappropriate or in opposite by our learned friends. But just to complete that line, just to say, it's one of those, my lady, that as a proposition, as your ladyship put it to me, like I said earlier, it is fascinating, but I qualify it by saying it is not one that this or these applicants can take advantage of, because it is simply unavailable on the facts.
Yes, thank you.
So the issue, my lady, is simple. They've got to say, these are the duties the SABC cannot do. The SABC can, the SABC must do A, B, and C. What has happened here is D, E, and F. It infringes A, B, and C in this way, and this is the declaratory sick. The case ought to have been as simple as that. But the difficulty is this, that it is for this reason that there is a deficiency in the pleadings. And I'm going to deal with the constitutional issue now in conclusion. And then the question of cost. The difficulty is, if these viewers that are being referred to in this wide national coverage that is the widest, to use my learned friends or to borrow from his expression in Africa, are presented with a totality of the entirety of the facts. There is no poisoning of the minds. They are not only being told that there is a GNU 1, there is no endorsement that the usage of the term is correct, and there's no suppression of alternative views that this is a politically contested term. That's what a broadcaster is supposed to do on the facts of the case. It might be different in another case, and that is why litigation is not a one-size-fits-all. It's got to be determined in the context of the facts that are invoked, or the facts and the context in which the prescripts are invoked. Lady, our learned friend bolstered the argument with reference to what Ms. Zill said. You recall he took it to the replying affidavit. Your ladyship is aware there is a supplementary affidavit in the papers. Might I just give your ladyship the reference?
Is there a dispute about whether that goes in or not?
No. The supplementary was presented in the
urgent application.
Yes, in the urgent, and all that the supplementary does, my lady, it is to say it refers to different articles on different days to illustrate the point that this is a political issue. Your ladyship is given other references where Ms. Zill has actually referred to this as the GNU. And just for your ladyship's notation, the supplementary affidavit is at 02-33.
Yes.
So there are a number of examples. So, and this shows why it would be risky to go with what a politician feels on a particular day. All that you will do is you'll report that on a particular day she said we are not in a GNU. On a different day she said we are in a GNU. And these are the various examples that are listed from paragraph 6 of that founding affidavit. And also in the heads, my lady, we've also given your ladyship the references and Annexure A there too, where the applicants themselves refer to the government as the GNU. We gave your ladyship that quotation of the speech by the chair. I can't remember whether he's the chair or he's the deputy chair. Or he still occupies the same position that he occupied yesterday in that political party. But the point there is, Dr. Hlophe, in his own words, refers to the government as GNU. And he says, among other things, it's not a GNU. He says it is exclusionary because we don't want to go where we are not wanted. And he concludes by saying, but we also don't want to go there. In context, the leadership will remember, before the government was formed, and the leadership can take judicial notice, various political parties were approached, including the
I'm sorry, no. I don't
You
know.
object to my
Yeah,
judicially
Okay.
taking
to
notice.
giving evidence.
no.
I think that's fair enough.
Yes, no, my lady.
Yes.
But
No,
but the,
I know what you're getting at,
Yeah,
but yes.
yes, the point is each political party put its own preconditions. That's in the public domain. The MK party put its own. The MK and my lady, I'm not here pushing the position of whether it was correct to do this or whether it is the GNU or it. For present purposes, I don't even have to get there. Whoever entered into an arrangement with whoever, my lady, and they were calling themselves whatever from different contestations, that's in the political sphere. The SABC, this is the nub of the case. The SABC does nothing wrong in calling the government what it calls itself, with an explanation that this is a contestation, as I've said, my lady. I don't, so I'll be repeating that submission. And my lady, what is of importance as well to note is, once you are in the realm of a breach of the internal policies of the SABC, then the remedy should lie there. You don't even reach the Constitution. And my lady, it leads me to the next point. If I might just start by asking your ladyship to turn to paragraph 4 of our heads of argument.
Yes. What page is that?
I'll give your ladyship
Thank you.
the page in a moment. I'm told it has changed, so might I give your ladyship the new number?
Yes.
My old one is 19-71. Oh yes, it's still 1971. Yes, my lady, it is. Oh, so at least this part did not change.
Yes. Yes.
In paragraph 4, we make the submission. The application is not a constitutional matter. It is well established that constitutional matters must be properly pleaded. An issue or matter does not become a constitutional matter merely because an applicant calls it one. And we quote that decision, and there is also the decision in footnote 2. Sorry, footnote 2. Mbata versus the University of Zululand. And if I could just ask your ladyship to make a note. This quotation in paragraph 4 from the Chiro's judgment, your ladyship will find at 19-522. Your ladyship does not need to go there. Just to make a note. Where the Constitutional Court held that in order to reach the question whether the applicant's fair hearing right has been infringed, the underlying factual question whether Sinyatsi AJ was conflicted must be resolved. In truth, therefore, this is a factual dispute dressed in constitutional garb. That does not engage our constitutional jurisdiction. That should be the end of the matter. If I can just stop there, because that is really the principle. And it is important for two reasons. One, it is relevant for purposes of costs, because once it is not a constitutional matter, then it's purely a factual issue. And a factual issue here, editorial policies, etc., etc. And if I can just, against the backdrop of this, ask your ladyship to then go to the founding affidavit where we had initially stopped when we were dealing with how this case is pleaded, or has been pleaded. In paragraph 49, page 02-739.
Sorry, I was just making a note to give me that page number again.
02-739.
Thank you. Yes.
Constitutionally speaking, the applicants will invoke the following rights. The full sections are not all cited in full. to avoid unnecessary prolixity. So it's section 1, 7, 9, 10, etc., etc. Really, what your ladyship will not find with respect is an engagement on how these rights are infringed. You have the right to dignity, for example, in 10, you have the right to equality in section 9. There is no factual engagement with these rights. Say this is how they've been invoked, or this is why they're invoked, this is how they are breached, and this is why it entitles us as the applicants to a declarator of constitutional invalidity. It's the same problem. And this is the same problem that your brother, Justice Moki, was faced with recently in Mkhwebane. And perhaps if I can pause and ask the leadership to go there, because the leadership will see the wording that is used is almost similar. The difference being that in this case it's paragraph 49, in the Mkhwebane case it was in paragraph 48 of that founding affidavit. The Mkhwebane judgment, your ladyship will find at 19-366. Oh, sorry, there's a new number. But I'm told the new number is 27-249.
It's the same document.
Yes, but it's the same document. If your ladyship can just bear with me. My lady, what was involved in the case was an interpretation of contract, and there were all sorts of constitutional rights that were referred to. And your ladyship will see in paragraph 45 of the judgment, his lordship says, the interpretation of a contract is not without more a constitutional matter. This is only the case where the claim advance requires the consideration and application of some constitutional rule or principle in the process of deciding a matter. There is no constitutional rule or principle that merits attention in interpreting the clause. And then in conclusion, in paragraph 46, an issue does not become a constitutional matter merely because a litigant calls it one, or where the issue is dressed up in constitutional garb. And the court refers to the Mbata judgment, which is the one that we've also cited in our heads. That's the first one. The second point, and I'll take you. I'll find a reference in the judgment. I've missed it somehow. Can I just ask my juniors to find it for me? Where the court says the mere listing of constitutional rights without proper engagement is an invocation of the constitutional claim in the abstract. In other words, it is a non-specific constitutional case. 48. Thank you, Malady. Yes. In paragraph 48. Thank you, Malady. I ought to say more about the applicant's claim that the respondents infringed several provisions of the Constitution. The applicant's pleaded case on the infringement of the Constitution is non-specific. She averred as follows in her founding affidavit. Given the large number of constitutional provisions which are relevant to this application, which have either been breached, misapplied, or misinterpreted, and in order to avoid unnecessary prolixity, I do not quote them, but list them as follows. She then listed the provisions. The applicant says the provisions have either been breached, misapplied, or misinterpreted. She did not elaborate as to which provision of the Constitution has either been breached, misapplied, or misinterpreted. So in other words, the debate there, it was, again, the debate that is similar to the one that we had in relation to Paja. You can't just list constitutional grounds and not plead. Section 1 here is the rule of law. What is it about the rule of law that has been breached as a foundational principle of the Constitution, and why is it a constitutional matter? Section 192 in 49.2, I proceed in the founding affidavit. We know Section 192 prescribes that national legislation should be enacted for the establishment of an independent authority. 192 is the provision that gives effect to the formation of ICASA. Nothing more, nothing less. ICASA has been established in terms of the ICASA Act. There is the Broadcasting Act. There is the Electronic Communications Act. Why is this infringed? By way of a provision that talks to the establishment of the regulator. And this is why our courts deprecate this kind of conduct. You can't plead a case in this manner and leave it to the other side to figure it out, to say, how is this right implicated on this fact? How does it connect to the conduct? And why does it entitle one to constitutional relief?
There's constitutional court authority for that proposition. I was trying to think of the name of the case, but I know there's constitutional court authority in relation to how one frames one's review grounds.
I'll deal, Malida, we'll find that proposition. So we'll find the authority for your ladyship, but your ladyship is spot on. But it's purely a question of pleading. It's a foundational or an elementary principle of the discipline in motion proceedings. For example, a witness could not, if they were giving evidence and say this, how do you cross-examine this witness? You have to say, but okay, you say this. If I was cross-examining the witness, I would say, but you've listed, or in your evidence in chief, you mentioned section 32. How is that a relevant consideration for purposes of conduct? And your leadership would know, for example, section 32, it is the right to access to information. And that section talks about the need to prescribe national legislation. And that national legislation has been prescribed in the form of PAIA. And what that means is if you have a complaint about access to information, you can't rely directly on section 32. You would go to PAIA. That's why we say it's not a constitutional matter. Even if this has been elegantly pleaded, it would be met by the principle of subsidiarity, because you can't rely directly or invoke the Constitution directly and bypass the legislation. So that would be the problem, and that's why this is a difficult case to plead to, because you list complaints about facts in section C, and then you say, well, I'm going to pull it all together. It can't be done, my lady. Then in 50, my lady, which then leads to this point on which we should conclude. In respect of legislation, reliance will be placed on inter alia the following. The applicants would rely on sections 2, 3, 6, 8A, and 10 of the Broadcasting Act, which incorporates the SABC Charter. Now, therein lies the problem. There are two difficulties that are insurmountable, we submit on the part of the applicant. The one is this, that if there is legislation, and that's the submission I made earlier in the introduction, if there is legislation that is, which has been promulgated that deals with the subject matter, you find your relief in the legislation. So apart from the fact that the case is inelegantly pleaded. Again, we have the same problem. You don't know why Section 2, why Section 3, how, etc., etc. But let's...
So that submission
Yes.
is that it goes beyond the exhausting of external remedies.
Internal. So,
The point is that it offends the subsidiarity principle, which is bigger than that.
yes. So in other words, even if you were to assume in their favor, just confining myself to 50.1, assume in their favor, which we don't accept, that they have established a case here at 50.1. You don't reach the Constitution. You dispose and or determine the matter on the basis of the governing statute that is applicable, which is similar to what FXI did. Section 10 is what FXI dealt with.
Yes.
And an internal code of the SABC, which is here, in this case, it's the SABC Charter. You go there and you say, this is the problem. And then you seek an error of law in your review, as FXI did. Or whichever one is applicable in the grounds of perjury or legality. But you plead it. Constitution, my lady, you don't even get there. We have included for your ladyship the Sandu judgment, and if I can just give your ladyship the reference in it's 9-1106. And my lady, that is paragraph...
No, that doesn't come up. Is it 09?
Yes, 09
dash
1106.
1106. No.
Sorry, my lady, I might be incorrect. I assumed that the 0 has been cut out. Mine is 9. It doesn't have the 0, but it's too close to the start of the page, so I assumed the 0 has been cut out.
Well, I even with 9, it doesn't come up. Even with out the 0.
My lady, might I just read the
Yes, please.
the paragraph?
Yes.
Lady, just to make sure, it is 2007, Volume 5, SA 400, double C.
Yes.
And paragraph 51. I'm not going to deal with the code. Sorry, yes. In 52 as well, my lady. And I'm just going to read 52 because the 51 is where there is specific legislation that is enacted to give effect to the Constitution. A litigant may not bypass that legislative scheme and find
Yes.
a case in the Constitution. In 52, Justice O'Regan says, accordingly, a litigant who seeks to assert his or her right to engage in collective bargaining under Section 23(5) should, in the first place, base his or her case on any legislation enacted to regulate the right, not in Section 23(5). If the legislation is wanting in its protection of Section 23(5) right, in that litigant's view, then that legislation should be challenged constitutionally. To permit the litigant to ignore the legislation and rely directly on the constitutional provision would be to fail to recognize the important task conferred upon the legislature by the Constitution to respect, promote, and fulfill the rights in the Bill of Rights. The proper approach to be followed, should legislation not have been enacted, as contemplated by section 23.5 need not be considered. So there's that difficulty that arises from paragraph 50.1, ALA FX Act and these other authorities, and from the point where we started that this case does not engage any constitutional principle, because as the leadership correctly observed in our main submission, if there's no expression, you don't even get to section 16. So we are purely on a factual issue. My lady, if I can then just give your ladyship, as I had undertaken to do so earlier, these following references. In the Mkhwebane judgment, may I give your ladyship these references, and they relate to the Paja point.
Yes. That's the judgment of Muki J.
Muki, yes, at 19-366.
Yes. Because there are many Mkhwebane,
Yes.
so that's why I wanted to
Yes, my lady.
make that clear.
Yes. In fact, it does have the citation, the 2024 JOL
Thank you.
16467. But the citation is at 19-366.
Yes.
In paragraph 49 of that judgment, His Lordship says a court cannot give declaratory relief in terms of section 1721A on no specific assertions that there are breaches of the Constitution. I conclude that the applicant failed to lay a basis for the court to exercise its section 172A power. That's paragraph 50. There is therefore no need to inquire into the relief she seeks in terms of section 1721B. So those are paragraphs 49 and 50 in relation to 172. Then in paragraph 52, I had set to your ladyship that 7-pointer requirement in the Motau judgment. His Lordship Justice Smoky deals with it in paragraph 52 of the judgment at 19-382. Now, my lady, this is purely on a belt and braces that if your ladyship gets to the alternative relief. I had said there is a problem of pleadings, but also there is a jurisdictional difficulty for the proper invocation of Paja as an act to rely upon. In 52, the court inquired from the applicant's counsel during the hearing whether the applicant met the Motau criteria. The court pointed out that these criteria are jurisdictional requirements for a court to exercise its power of review. The court was met with a non-specific response. And that criteria, or the 7 points requirement, your ladyship will find in paragraph 33 of the Motau judgment, which is in the bundle.
Yes.
And His Lordship concludes in paragraph 60 that decision refusing the applicant a gratuity does not constitute administrative action. Paja review is not available to the applicant. I now consider whether the applicant has made out a case for legality. My lady, we've dealt with this issue both from a pleading perspective and from the law. We've cited in our heads of argument the authority that deals with the test for rationality. And we do so, my lady, in the abstract because there are no facts that are engaged for the lawful invocation of a legality. You've got to say it's irrational in this way and that way and that way. I showed your ladyship in the founding affidavit. There is just a conclusion, a legal conclusion without any facts. Your ladyship will recall, I think it was in just to make sure, my lady, it's in paragraph the alternative relief. Sorry, it's in E. Your ladyship can just So if your ladyship can just bear with me.
Yes, I will.
It's paragraph 77. But your ladyship does have it from the initial submissions that we made.
Yes.
My lady, for the reasons that we've submitted in our heads and the authorities that clearly indicate when is a matter a constitutional or a matter that is purely one of fact, we submit this is an application in which costs should follow the result. We ask your ladyship to dismiss the application with costs, including costs of 2 counsel, one of which is a senior counsel, and on scale C. So might I just take
Yes.
an instruction from my chair? So, my lady, perhaps, just purely out of caution, there is an issue that does not arise from the pleadings. But it's just to give you leadership context about it. Yesterday, we sent the applicants, or we arranged for 3 cases to be sent to the applicants that deal with the principle of subsidiarity and constitutional avoidance. It's nothing new. It's a point. That's why I started in paragraph 4 of our heads. But all that happened is, in specific terms, the relief is incompetent because of the principle of subsidiarity. But all the arguments your leadership has seen, we make them with reference to FXI, with reference to Chiroz, Mbata, etc. So what happened then is our attorneys sent the judgment, but without the covering email that my junior had said, please tell them expressly we are raising subsidiarity. But it's neither here nor there, because that argument we've made in any event in the papers, just not labeled as subsidiarity, but it's a point of law if there is any controversy about it. And our learned friends can answer the case. If they need more time, they can file supplementary heads on the principle of subsidiarity to cure any prejudice, if there is. We can't imagine, because we've always said it's not a constitutional matter. Lady, unless there is anything else.
No, thank you, Mr. Mtau.
Thank you, Lady. Those are submissions.
My lady, could I just ask, without even adjourning, there was just an issue about which pulpit. that one is, I had offered mine to Mr. Mtau because it has the support, and this one. So if you can just do that.
Yes, of course.
For half a second.
Take your time.
So, my lady, it's not an indication by any means of which of the 2 pulpits have been ordained. But it's clearly a issue of convenience.
Oh, which one is for snake taking?
Thank you.
Thank you. My lady, you know, I don't know where to start. Or in fact, to be honest, I should not even start at all, because the case has not been dealt with at all, and I'll demonstrate, my lady. So I apologize to your ladyship that I have to demonstrate that. Otherwise, what I should do is just to sit down and we all go and your ladyship decides the case. Let's start with this thing of subsidiarity. The reason why I raised that question before lunch was to give my learned friend an opportunity, because he said they've given us notice about subsidiarity. And I had not received any such notice. So I thought maybe it's my fault. So I asked his junior, asked my junior, and so there was no such notice, we were now told, that was given. But there were 3 cases that were given, not yesterday, at 8 p.m. last night, on a Sunday, just the night before the hearing. That's, I mean, even in an urgent application, that kind of notice would have been absurd. So we are not given any notice about subsidiarity at all. If the court is going to be asked to consider anything about subsidiarity, Mr. Malefra and Mr. Mtau is right, then we would have to be asked to address it. Even assuming that it's allowed that a party can just rock up on the day of argument and raise an issue like that without warning the opponents.
Nobody will be taken by surprise in my court.
Yes.
That's the first thing.
Well,
secondly, it has been raised. It's been squarely raised. To the extent that you feel that you're taken by surprise, you must tell me what you want to do about that and let me make the decision. Mr. Mtau says you can put in further heads and he won't object. He says this is a matter of law. He says to the extent that you want to put in heads, that can be done.
Thank you, Maled. I'm grateful to the kindness of Mr. Mtau. But Mr. Mutau's duty is to plead his case. He's been lecturing everyone here about how pleading should be done. Next time, before I send him the card to congratulate him, we'll say you must plead subsidiarity. If you don't plead subsidiarity, you must notify your opponents in time. This case comes from July last year. And allow them to respond thereto, or at the very least, to research the point. So, I mean, you can't be, I've never seen a situation where you can be ambushed in the courtroom, not even 5 minutes before, with a legal point. But
I won't allow you to be ambushed.
Thank you,
So
Madam.
to the extent that you feel ambushed, and to the extent that you feel that you need to do further research on the point, because it is a law point,
Yeah.
and I'm inclined to agree that it has been latterly raised. Well, I'm asking how you think that can
Let
best
me-
be dealt
yes.
with,
No.
because it's something I can't ignore.
Yeah.
It is a law point, and it does have a place in this debate.
Well, my lady, no, there's law on this. Your ladyship can actually ignore it, but I'm not going to ask you to do it. But the law, which the Constitutional Court, Madranga J, I just forget the name of the case, said that if you raise a law point for the first time, then one of 2 things will happen without having pleaded it. Either you, what your ladyship is saying, you give the other side a chance to plead and address it, or the court simply ignores it because it's not allowed. So it's not so much what your ladyship allows me than the fact that your ladyship should deprecate this kind of litigation, where you just stand up and come up with a point that has not been foreshadowed, even by a phone call or anything.
Well, you know and I know that sometimes on a Sunday night, something can come to one when one has not necessarily put it into the papers, or somebody else has drafted the papers. So I'm sure that it was not the intention of Mr. Mtau to take you by surprise. But I am able to accommodate that.
Yes, thank you, my lady. We will deal with it, yes. There's a rule for that, by the way, it's called Rule 65E. When such a thing happens, you put a supplementary affidavit, as Mr. Mtau did in the urgent court about the Helen Zille issue. When he felt that this had not been raised in the founding affidavit, he invoked his right in terms of Section 65E and filed a supplementary affidavit. But let me make it easy for everyone. I'm not going to ask for any extra time, because the point is actually meritless. Let me just deal with it here. Yeah. The point is this: subsidiarity does not arise in these kinds of circumstances. Subsidiarity simply means the following: that when there is a constitutional right, which right has now been also covered in legislation, a party seeking to invoke that right must first invoke the litigation, rather the legislation, right? That's the principle of subsidiarity. That's why we come here and we talk about PAJA. Because what we're doing is actually we're invoking Section 33 of the Constitution, administrative rights. But you can't do that because the administrative Section 33 says that there's going to be an act, and that act is called PAJA. So therefore you come through PAJA. Okay. So so here's the thing. We are here about, we say the rights, we say I've listed the rights that we're invoking. Section 9, Section 10, Section 16, Section 20, and Section 32 of the Constitution. Now let's just take at random, we can just throw a hat and choose any one of those. Let's take Section 16 or Section 10. Human dignity. There is no such thing in South Africa called the Human Dignity Act. All right? So the only place where you invoke human dignity rights is in a court of law by invoking Section 10 of the Constitution. Similarly, there's no such thing in South Africa called the Freedom of Expression Act, which would have provided that principle of subsidiarity. So those rights for which, unlike Section 33, have not been imbued with a particular act, must be invoked in a court of law. So there's no subsidiarity issue to deal with, even if it was properly pleaded, which it is not. So let's move on. So we've heard all about PAJA. Mr. Mutau spent the first 30 minutes dealing with PAJA, and the next 30 minutes was about the facts of the FXI case, and then it was that this does not involve the Constitution, and then he gave us the case of Tirotsi, which deals with constitutional jurisdiction. Then he told us about all the facts of the Kwebane case, which has nothing to do with this, and then the subsidiarity point, which I've just dealt with. So let me just show your ladyship that everything he has said here has got nothing to do with this case we are about to hear today. The PAJA issue and the whether it was pleaded this way and that way, your ladyship pointed this out in the morning, that in fact that's something we may never reach there, because that's something that's invoked in the alternative. This case is about 172 1A of the Constitution, and PAJA is an alternative. And if PAJA doesn't apply, there's a further alternative, legality. So, firstly, the points that were made were meritless, but even if they were full of merit, so what? Because the main case is still here in front of us, unaddressed, and the legality review is in front of us, unaddressed. And the only issue that we are told about the PAJA challenge, so to speak, is the Mutau list. But that is misleading the court, because in the founding, rather answering affidavit, at paragraph 44, that's the answer. That complaint is qualified as follows. You'll go to paragraph 44 and 45. So the impugned decision is not an administrative action under PAJA. That's the Mutau point. Then the code PAJA, well, we all know what PAJA says. But here's the point at paragraph 45. that is being raised. The impugned decision,
That's 45 of the answering affidavit.
yeah, of the AA, yes, my lady. Yeah. The decision to refuse to comply with the request to refrain from referring government does not adversely affect the applicant's rights or anyone else. Decision does not satisfy all the requirements of the definition. It is therefore not administrative action. In other words, what is pleaded here is that having given us the definition, the reason why it's not administrative action is because it does not satisfy section 1B. And even in section 1B, that part that says adversely affects any rights of any person. Okay? So that's what's pleaded before you as the ground for the one ground that's supposedly missing. Okay. So we can't now, in argument, bring a different case. If the case is that this action does not adversely affect the rights of the applicants, then I'm going to give you a one-line answer to that, because that's an absurdity. The answer is simply this: the violation or the alleged violation, or even threatened violation at that, of the rights in the Bill of Rights are ipso facto harmful or adversely affect the bearer of those rights. I mean, that's like Constitutional Law 101. And in Fose, I think is the case, one of the cases that we just look at paragraph, I think it's paragraph 36 or 37 of Fose. That's a case that happened in 1996. It was my first case in the Constitutional Court. In Fose, it was said that the violation of constitutional rights cannot be equated to the violation of interpersonal rights, as the leadership knows. That by alleging a violation of the constitutional right, per se, you are saying this is a violation of the Constitution itself and the public. It in fact, in other words, it offends all of us that the Constitution is violated.
Yes.
If it, yes. So that principle is trite. So if this is the only ground upon which the so-called Mutau list is invoked, then God help us, Mutau list by Mutau SC, then I'm afraid then it should be it's not worth the paper it's written on. So because you don't do that, you can't say when you are pleading a constitutional case, well, you offended my dignity, in that I felt bad, or this and that and that. The mere fact that you deprive me of my political rights, you deprive me of my dignity, you deprive me of my right to receive information is itself.
You say that therein lies the context
the adverse effect, yes.
of the right.
Yes, you can't then say someone who has said that has not told you what is the adverse effect. What is that? What must they say? No, you've killed me and you've offended my right to life, but I must tell you how that has an adverse effect. Never heard of such a thing. Anyway, so that's the kind of thing that that has been addressed here. I'm sorry, my lady. If your ladyship just give me.
Yes, take your time. You've got time.
No, I've lost my yellow pages.
Mr. Matar left you with an hour.
Yes.
I hope you won't
Even more.
go more than an hour.
He's going to get another Christmas card. Yeah.
So in the next case, you owe him time.
I will, absolutely. I'm sorry, man.
If that was the standard in the cases that we've done, he owes me more.
We'll do an audit, man. Anyway, I'll find it. Sorry, my lady. Yes, okay. Yes, that's fine. Thank you. Well, my lady, not to flog a dead horse, literally. my Leonard Jr. Is this our hands? Or in Grace Marine Hot Bay, that's another case which deals with the Mutawa list as a
Yes.
knows. At paragraph 23, it says, while Paja's definition purports to restrict admissive action to decisions that as effect adversely affect the rights of any person, I do not think that literal meaning could have been intended for administrative action to be characterized, but its effect in particular cases seems to be paradoxical and finds no support from the construction that until now been placed. And then it goes on. I don't want to. It's an obvious point, my lady, that ipso facto, once the rights are affected, then it's adverse. It's adverse. Those rights are being adversely affected.
Well, I understand Mr. Mata's argument to be you've got to set up the content of the right. When you are invoking a right under the Constitution, you have to set out the content of that right within your factual complex. That's as far as I take his submission to
that's
go.
A completely different submission. I'm talking about his submission around the Mutau point. In other words, whether it's administrative action or not. You don't have to. There's no other way to understand it except what is set up in paragraph 45, which is that it does not adversely affect the rights. I'm coming to that point about the constitutional rights and so on. This is just about Paja. It's got nothing to do with those issues. Mr. Mutau's pleadings say that his only complaint on the definition of administrative action is that it does not adversely affect the applicants. And I've just shown that that's just nonsensical.
Well, he says what rights, what constitutional rights
Are affected.
lie at the centre of your constitutional jurisdiction, which you motivate for.
No, my lady, I'm coming to that. That is not what, that question has got nothing to do with the Mutau list. I'm coming to that question. Mr. Mutau says at paragraph 45, and I'll read this again if I have to, his complaint about the definition of Paja is that the conduct has no legal effect. Full stop. There's nothing more that he says. He says what your ladyship says, but in another point which I'm going to come to. And I'm saying, let's get rid of that Mutau list of adverse rights. I've read with the authorities, and that's it.
I think that's sensible. Let's put that list aside.
Yes.
So now we come back to the question that I asked.
Yes, which is the
which
next
is
point.
the content of
Yes,
the right.
yes. As long as we agree that the administrative action definition point is meritless.
Well,
then we
no,
can
that
come
is
to
not. That's not what I said. I said that I accept the submission, and for the purposes of moving on, let's set that list aside. I understand what it means, and I understand the argument. So I'm not suggesting that I agree with any one of you. I just think I've got that argument. So let's move on to the next one.
Okay. All right. Well, let me just, for the sake of insurance, let me just say this: that in our law, every time you complain about the invocation, violation of a human right, as was said by, I think it was Ackerman in Fosse in 1996, then the harm, it's not like if you're doing an interdict, then they say, okay, what was the harm? The harm is assumed. Okay.
Yes.
Anyway, so if that's the only complaint, then it's the non-complaint. Now, coming to this issue of the what rights have been pleaded. Honestly, that one takes the cake, because it means, again, it's a failure to read the simple pleadings. I mean, this founding affidavit is only 30 pages, really. I don't know how it can be not read. Firstly, we were told that we did not ask for an exemption, which is there. I showed you that it's there. The second thing is that we're now told that we've just given a list in paragraph 49. I explained this in chief. I was thinking maybe a ladyship was going to put it to Mr. Mutau. That all that happens at paragraph 49, my lady, is what we call, there's a heading, a big heading there. It says the constitutional, statutory, and other regulatory framework.
Yes.
Right? And then it lists the sections. Section 1, Section 7, Section 9, 10, 11, 20, 32, like I did to you this morning.
And you say, I must go to each of those sections, and therein lies the content of the right.
No.
You...
No, that's not what I'm saying. I'm saying, my lady, anybody who has done pleadings or taught pupils how to plead, you say, you put your facts, what, then you say to the court, these are the legal prescripts we're going to be dealing with, or clauses of the contract, or whatever it is, 1, 2, 3. And then you then elaborate as to that, but you can't be faulted for having said, well, in this matter, we're going to deal with clause 10 of the Constitution, and clause 20, and clause 30. That's all we're saying here. Then, in the rest of your pleadings, you then say, why is clause 10? What's wrong with clause 10? Or clause? But how can somebody be allowed to come and say, no, you can't say, these are the sections I'm going to deal with?
I agree. I think you are allowed to say that.
Yes, and then you go to section
But I
E.
think you need to be specific, and I think for the purposes of this debate, I don't want to misunderstand you.
Correct.
What is the right? Can you tell me the right in your own words, which you say has been transgressed?
Yes. But, can I answer that question in two ways?
Yes. I'm going to write it down.
Yes. The first one is, before we get there, my lady, I want to please make this point, that what I'm debating about now is the accusation that all we have done here, we came here to this court and met people, and we said, these are the rights that are going to be invoked, and we sat down. All these other 30 pages don't matter. It's only the list that matters. It doesn't work like that.
Well, that's why I'm giving you the opportunity to formulate the right that you say has been breached.
Okay, two things. That exercise has been done from paragraph 55, 56, 57, 58, 59, 60, 61, 62, 63, 64, 65, 66, 67, 68, 69, 70, 71, 72, 73.
All right, can you formulate it for me?
Okay, so that's the, well, I'm just telling you, my lady, first that it is formulated in the papers.
You said earlier that the right to life, if somebody has been killed, it does seem to be seem to be clear that you're dealing, or if somebody is threatened with death, that right is clear.
Yes.
But rights are not where they reside. Sometimes needs to be fleshed out.
Yes.
And I'm asking you to tell me where your rights reside.
Okay. Okay, my lady, we say ad nauseam in the... Let me put it this way, my lady, maybe it will assist your ladyship before I answer. If it's a criminal case, okay, or a labor matter, there's something called a charge sheet, all right? There you just say, you breached this and that and that and that and that. Fine. You're allowed to do that.
Yes.
But you can't end there. You must then have something called summary of facts.
Yes.
So I'm saying the summary of facts here, in this case, is from paragraph 20 to 48. Okay?
And so you say that summary of facts is not something that you need to deal with from a statement perspective? You say I must just take all of those facts, and on that basis, I must understand the content of the right.
Now, lady, if you allow me to finish my sentence, then I'll...
Yes.
So you have in the criminal case the charge sheet. Okay?
Yes.
That's the list. Then you have a summary of facts that tells you so and so, this one stabbed this one did that, and da. That's called a summary of facts.
Yes.
Right? Then you have what we have here. Go to paragraph E, legal analysis.
Yes.
Now the legal analysis is the one that I told you that goes from 56 to 73.
All right, just take me to that page.
Okay.
Let's have a look at the
Okay, I'll
legal
do it,
analysis.
let's
that's
do
done.
it bit by bit, yeah. Okay, so
So-
what I call the charge sheet or the list.
Yes,
You-
what page? What page?
It's page 02-159. And I think that Mr. Mta was using the other bigger number, 700 and something, but it's the same. There's a lot of duplication.
I used 02.
I think it's 700 and something. Yeah.
No, 02.
So 02159. On that version of Mr. Mta, it would be 02700 and something. Okay.
No, 02159 is Geleke Kansa, the case.
No.
The University of Stellenbosch.
Okay, no, it's not. That's probably a
So
different.
let me just go then
Okay,
to
let me just say, my lady, we really shouldn't be spending so much time on this because it's just the point I'm simply making is that the pleadings must be read as a whole. Yeah. So
Yes.
it's section D or paragraph 49 of the founding affidavit. So maybe someone will give me 02739. Yes.
Thank you.
Okay. Are you there, my lady?
Yes.
Yes. So that's what, let's call that the charge sheet. That's where we list, that's what we're now being accused of. Simply because we've listed, we say, we're speaking, we invoke the following rights: 1, 7, 9, 10, 11, 20, 32, 192, and then we say which parts of the charter and what. That's all we do there. But what I call now the equivalent of the statement of fact is, you'll find that from paragraph 20, that's paragraph 20 to paragraph 48. Okay? And then, which is the most important part, the legal analysis. So now you've said the facts, you've listed the sections, now you must do the legal analysis. That's where you explain how all that hangs together. It's called, some people like to plead it, they call it applying the law to the facts. It's the same thing. Legal analysis, you call it whatever you call it. And that is where we then move. Then we say at 56, we're now telling you how those rights that we listed in 49 are to be applied. So the apparent motive of the ANC in its direction of the current political arrangements was to hoodwink its supporters and so on. And I read that earlier. Then we say at 57, to be sure, the ANC acknowledged, it readily acknowledged that the ANC we acknowledge that the ANC is entitled to embark on a political propaganda campaign aimed at its constituencies. Accuracy is not an essential requirement in the area of business. When say the commercial or private media is not necessarily compelled to act independently, you might also add impartially, or it sponsors for preferred political organization in favor of, I suppose. And then we say, what is illegal? We're now explaining in detail what's, not just listing those things. What is illegal and subject matter of this application is for the SABC, which is an organ of state,
Yes.
constitutionally enjoined to obey certain standards in the discharge of its public duties, to mimic a political party or parties by adopting hook, line, and sinker a patently inaccurate and subjective definition of the prevailing political arrangement.
And what right is that?
Yeah.
That is infringed.
Okay.
Because I'm giving you the opportunity to
Yes.
formulate
Yes.
the right, because Mr. Mattal
it's not formulated.
says that you haven't formulated
No,
it.
I don't have
So
to. It
now-
was formulated by the writers of the Constitution. It doesn't have to be formulated
Yes.
by me. The writers of the Constitution say everyone right? Everyone includes Mr. Jacob Zuma and the MK party. Okay? Yeah. So it says everyone, and these are the applicants before you,
Yes.
has the freedom of expression, which includes the freedom to receive information.
Right. So that's
the right.
That's the right
Like I
that
said
you.
in the, at 10 o'clock in the morning.
So it's the freedom
16(1)(b).
to receive accurate information.
Yes. Well, you remember we made that qualification. We read it with class and J. Said accurate,
Yes.
independent, impartial.
Yes.
And, yeah. So I even said to you this morning, you might therefore rewrite section 1B and include those words from class and J. So that's the right. It's already formulated by the founders of the Constitution, and that is the right we are here to deal with. The
Can
second
I
right-
come in?
Sorry.
As I put to Mr. Mattal, is this a freedom of expression matter? Because
Yeah.
I understood you to argue that it wasn't.
No. You understood me wrongly. I said, and I'm saying it again, in the majority, about 90% of the cases in South Africa that deal with freedom of expression, deal with it from the point of view of the media.
Yes.
Right? Remember I said that this morning.
Yes.
But
indeed.
in this case, this is one of the first cases, and that's why I was saying this case is unique, where we are dealing with freedom of expression from the point of view of the citizen. In other words, the right not so much to impart information, but to receive.
Yes.
Okay? That's what I said here this morning. So that's the right. So to be told that the right has not been formulated is actually just a waste of the time.
Well,
of
to express one's opinion is a right.
Yes.
To receive
Receive
accurate information
Yeah. Is a right.
is a right.
Yes, thank you.
But it's a right, Mr. Mattal says, that is dealt with in the subsidiary statutory provision.
Yes.
And he says I must go there.
Yes. My lady, can we please deal with one thing at a time? Because now we're moving to another topic which I will address.
Yes.
I was simply addressing the absurdity that was said in this court, that we have not said how the rights have been, when we have done so. I was just reading it to you.
Well, you've
So,
done so on the
yes.
basis, as I understand, and I want to understand your argument. You've done so on the basis that you say that the right that you rely on as having been infringed
Yes.
is not the right to express yourself or otherwise, but the right, you're saying you're looking at it from an opposite perspective, and you're saying that is the right to receive accurate information. I don't understand how that correlates,
No.
because people have the right to make even inaccurate, nonsensical,
False.
false.
Defamatory.
They've got the right to express themselves because they believe that is their right.
No.
So it's not. We're not turning it around
Yeah. No.
on your argument.
Yes. I understand, my lady.
Yes.
Well, firstly, that's not true. Nobody has the right to do everything. And to I think it was Voltaire, one of those philosophers, said you might have a right of expression, but you don't have the right to shout
Fire in a
crowded theater.
Yes, I have
So
that.
that's
So there are limitations.
Absolutely. That's the issue.
But
that's really the only issue.
That's the issue.
Yeah, there's no
Yes.
one who has a right, as long as you believe something. If you believe there's a fire, then you can shout it in a crowded room. It doesn't work like that. And the reason why your ladyship says it sounds confusing is because the formulation that your ladyship gives is wrong. Your ladyship says, I said, which is I did not say, that it's not freedom of expression, but the right to receive information. That's no. The Constitution says, there's no but. The Constitution says the right to receive information is freedom of expression. That's why it reads as follows. everyone has the right to freedom of expression, which includes freedom to receive information. So there's no dichotomy. The right to freedom to receive is freedom of expression. Okay, so that's the first right. The second right, to the extent that I have to say this again,
Yes.
is the right to human dignity.
Yes.
Right? The right to human dignity is an adjunct to the political rights. That was stated in a case which I did in 2012 called Ramakatsa versus Mahashul.
Another case?
Yes, it's cited in the article. Your leadership, I don't have to go to.
Yes.
In that case, Musaneke DCJ said the following. I'm paraphrasing. Political parties, which is the second applicant, are the vehicles through which citizens exercise their political rights, right? And that political right to vote or to participate in a political party must be traced to what was said in the case of August versus the Electoral Commission, is a badge of dignity. In other words, when you vote, you are expressing your dignity. It's given our apartheid past in particular.
But and you say this impacts on the right to vote?
Yes. No, not the right to vote. Section 19, political rights.
Yes.
Okay. The section. Okay. Let me assist it like this, my lady. If you go to the article, and your leadership, I know you don't have it. You'll read it in your own time.
I will do.
But when you do, my lady, you should go to 19-999.
Yes.
Yes. This is what is said. This hopefully will explain everything. It says the heading is Constitutional Protection of Freedom of Expression. Then they quote the section, and then she says the following. Then she says, my lady, the South African courts have confirmed the value of freedom of expression in a democratic society on many occasions. For example, in Sandu, Oregon held that expression plays a significant role as a guarantor of democracy and facilitates moral agency of society. Let me just pause there.
Yes.
So the freedom of expression is, in other words, okay, let me put it this way. When you vote, my lady, you are expressing yourself, okay? When you join a political party, you are expressing yourself. So that freedom of expression in that sense is, as she calls it, a guarantor of democracy.
Yes.
So, yeah, okay? Okay, and then so permitting individuals to form and express opinions and ideas. Nevertheless, freedom of expression is not an absolute guarantee, nor is it a paramount value. Here's the important part. It is, quote, is quoting a case of Curtis, a web of mutually supporting rights, and must be interpreted in accordance with the constitutional values and other constitutional protected rights, including the rights to human dignity, to participate in free and fair elections, should be exercised with due deference to the pursuit of national unity. Here we go again. Yes. And reconciliation.
Yes.
In other words, to paraphrase, freedom of expression itself is an expression of dignity in the sense that the Constitutional Court has said so many times, but also it's part of one of its goals is to foster national unity, which we say has been breached here. So that's the dignity. That's the dignity angle or connection.
Yes.
Right. Now, then, my lady, it has also been said, in the same article that the SABC in particular, which is the same thing that Klassen J said, that the media, not even the SABC, even at a lower level, the media is both, and that point has been made earlier, and I think the court accepted it. The media is both a bearer of the right of the freedom of expression, but also because of what I've just read out, it also carries constitutional duties and obligations. So it is those duties that we invoke here, not the rights of the media to freedom of expression, but the duties that arise from Section 16(1)(b) in particular. Okay. So then the third one, and those two, I'm starting with those two deliberately because they are the ones that are not susceptible to subsidiarity, even if the subsidiarity point,
yes,
because they are not covered in any legislation. Then there's the right to citizenship, that's Section 20 of the Constitution.
yes.
Section 20 of the Constitution says, as a citizen, you are therefore, you have participatory rights. And that is why Section 19, unlike all the other sections of the Constitution, well, not all, most of the sections of the Constitution which says everyone has a right to do this, everyone has the right to do this, like Section 16. Section 19 says every citizen.
Yes.
So so that's former President Jacob Zuma says to this court that I am the first applicant in this matter, paragraph 3, and acting both in my personal capacity as a citizen of South Africa and also in my official capacity as the duly appointed president of the second applicant. So qua citizen, forget any other, even forget that there's a former president or whatever, just could be anybody in the street. That person as a citizen would be entitled to come here and say, my lady, I have been watching something that I find offensive, and as a citizen of this country, the SABC cannot do A, B, C, D. So that's the first applicant's standing, if you like.
As I understand it, the right is, you have the right to citizenship. It's
Yes.
not a question of locus standi. It's a question of if your citizenship is in some way offended,
Yes, or violated. Yeah.
violated, then you have the right to come and say, look, I'm entitled, I'm a citizen,
Yes.
I passed the test
Yes.
as far as citizenship is concerned,
concerned,
so you cannot violate my rights of
To
citizenship.
number one.
It doesn't mean that anybody who is a citizen can come to court. Obviously, every citizen, if they've got a cause of action,
Sure, of course.
they come to court.
Yeah.
So what we're looking for here is the cause of action.
Yes, but lady, maybe I'm not making myself clear. Go to Section 19 of the Constitution if you've got
Yes.
it there, my lady.
I do.
You do, okay. Here's Section 19 says, because it's not just citizenship in the air. It says, every citizen is free to make political choices, which includes the right to form a political party, to participate in the activities and what have you.
Yes.
So in these pleadings, and really, I don't know why I have to redo the pleadings because they're here. In these pleadings, we say ad nauseum that the conduct of which, the impugned conduct of the SABC offends against A, the rights of the first applicant as a citizen who is a taxpayer who pays licenses and all that.
I don't understand that. I'm sorry. I don't understand
All
that
right.
submission. I don't see how it offends rights of citizenship. The fact that the SABC refers to a GNU. I don't see
Okay.
how that
Okay, how that can... yeah.
how that
Okay.
affects the
Would
rights
you-
of citizens.
Yes, okay. If a citizen came and said the SABC is showing sexually expletive material, and I, as a citizen, I am offended by it, and I'd like the court to intervene, would you understand that complaint?
But the right you're describing now is not the right of citizenship. The right you're describing is whether there's a freedom of expression or not.
Yes.
So that is where the right is located,
No.
not in the right to the right of citizenship.
Yes. No,
But I have your argument.
Yeah, yeah.
I have your argument.
Okay, let me just, I can't do better than this.
Yes.
The Umkhonto weSizwe Party is, as I explained in the morning, a party that was voted by about 2.5 million people, right? 2.5 million citizens, right? The Economic Freedom Fighters is a party that was voted by about 1.5 million citizens. Between the two of them, they are voted by about 4 million citizens.
Yes.
Okay? Those 4 million citizens have been, by the insistence of the DA, excluded, as I explained in the morning, from political participation, at least to the extent
But
of
why? They can
of the-
vote. They're political. Their Section 19 political rights say that every citizen is free to make political choices,
No, man, I
which
thought-
is what they've done.
Yes, but I thought we covered this ground in the morning. The fact that you are allowed, if I say to somebody, Mr. Muela, you are allowed to go to Parliament. In fact, you are allowed to vote, you are allowed to go to Parliament, but you're not allowed to participate in the executive, or vice versa. You're allowed to vote, but you're not allowed to participate in the legislature.
But you are, because that is why you have seats.
No.
And that is why you have people in Parliament
Let me ask
that are participating,
Yeah.
elected people that are participating.
Yes. In other words, Mr. Helen Zille was dreaming when she says this arrangement excludes these people. So she was. I
But
don't
that's
know.
that's not the question.
No.
The question is, what constitutional right does it offend?
If you are excluded from politics, well, okay. If you are excluded from political rights, it's like saying to someone who says, "I don't want apartheid," and you say, "Why? What's your problem?" Because what rights of yours have been affected? That ought to be self-evident that the mere exclusion of a citizen from any political aspect of political participation is offensive to our constitutional scheme. Honestly, that's the very fact of saying to somebody, let's say on voting day, I'm going to lock you up on voting day, and you're not going to go. I'll only
That would directly
Yes.
affect your political
yes,
right.
because it's exclusion on one aspect, which is just voting. So here we're talking about exclusion on another aspect, which is participation in the executive governance of a country.
But why?
It's the same thing.
But why are your clients excluded from participation? Why? In the government of
Yes.
the country? Because they are in Parliament. They have their rights as far as their representation is concerned.
Yeah.
The fact that somebody coins a phrase that you say is exclusionary, it's not the same as excluding somebody from their political rights under
So they are
Section
free to-
19.
Yes, so they are free in terms of Section 19 or even in terms of Section 20 to participate in the executive governance of the country.
Yes.
How are they free? How are they free to do that? Between now and 2029, they are excluded. Okay, it's a fact. They are excluded from participating in the executive arm of the state.
Why?
Full
They've
stop.
got a vote. Parliament is not the operation of Parliament is not affected
My lady-
by whether something is called a GNU or not.
My lady, okay, Parliament is a separate arm of the state. It has nothing to do with this case. Parliament is called the legislature.
Yes, I
Okay,
know. I
so,
understand.
yes. So let's take that our yeah.
Yes.
It has got nothing to do with it. They have all the rights in Parliament. They can raise objections. That's got nothing to do with this case.
Yes.
There's something called the judiciary, the legislature, and the executive.
Yes.
And they are excluded from this this one, not this one, not the one of Parliament. Okay, so that's the exclusion, and the fact that they are not excluded from this one does not detract from the exclusion from this one. Okay, now maybe let me assist your leadership as follows. Let me show you why this exclusion thing is important.
Yes.
Paragraph 10 of the so-called statement of intent. That's the thing that was signed by Ms. Zille and Mr. Mbalula.
Yes.
It's MK3, which is the third annexure. It's 02-844, my lady.
Yes.
This is what it says. So let's now go back to the most basic principles of what was the intention of the parties. It says, the government of national unity shall be constituted in a manner that reflects genuine inclusiveness of political parties that are party to the statement of intent. And then it says further up, at 10, the GNU is constituted in the interest of all South Africans. Okay, let's just stop there and go back to the example I made this morning. Would you say something that excludes the entire population of the Free State or the Northern Cape is constituted in the interest of all South Africans? Yes or no? The answer is obvious. And then they say the GNU agree that the 7th administration, let's pause there. What is the 7th administration? It's not some social club. It's the state of South Africa. The state.
Well, it's the governing body.
It's the government. Yes, the government for all of us. Yeah.
Yes.
Yeah. And the fact that we are excluded from that government is a problem, or should be for anyone.
Well, you're not, because you can go to Parliament and you can make your voice heard. That's the place to do it. So you're not excluded.
All right. Then they say, then it says somewhere else, rapid, inclusive, and so they talk about inclusivity now. 11.8, strengthening the social cohesion, nation building, like we spoke about, and democratic participation, and so on. Parties commit to an all-inclusive dialogue. Government of national unity shall be constituted in a I've already read that. Stable and responsive governance which meets the needs of the people in the province. Now, let me say this, my lady, just to maybe to assist your leadership to understand the exclusion point. Let's forget what Ms. Helen Zille says, and at least accept what we agreed in the morning was common cause, that it was a precondition and a foundational principle of the arrangement. Let's use that neutral word there, of the arrangement, that it must exclude certain people. So let's say, for example, it says we're going to have this document, but we exclude all women, and you call that national unity and an inclusive document that is in the interest of all South Africans. You'll be laughed out of court, correctly. Because how could you say something that says itself, it was entered into on the basis that no women must participate in it, is all inclusive and all these nice things? You can't. So that's the first thing. The second one, my lady, goes to, and it's a point that is made in our, just watching the clock. It's a point that is made in our funding papers, my lady.
Yes.
Where we say, you remember we use the GNU thing just generically, but it's GNU, GPU, so-called.
Yes.
And
it permeates.
Yes, it permeates right through. Yes.
The structure.
Now listen to this one, my lady. And if this doesn't convince you, nothing ever will. There are three, we say in the papers, there are three different arrangements in 3 different provinces. Okay? In KZN, there's a majority government, right, made up of the ANC, the DA, the IFP, and a few others. It's a majority government. What do they call it in this? The government of provincial unity. Okay. In Gauteng, there's a completely different political arrangement, which in politics is known as a minority government, where is the one we're talking about the 2%, where the party that is in charge only got 36%, and is governing as a minority. What is it called? Government of provincial unity. These two things that are completely different are called by the same name. They can't both be the same thing. And then in Northern Cape, a different arrangement happens there. There's the ANC, which is in a coalition with the Freedom Front Plus. What is it called? Government of provincial unity. So you have three distinctly separate and different things being incorrect. It can be correct in all those three cases. If it's correct in KZN, then it's false in Gauteng. If it's correct in Gauteng, then it's false in the Northern Cape and KZN. So that's the clearest manifestation that these terms are just being abused. Here's another one, at the so-called GLU. This one even has racist undertones, because it looks like it will only be called Government of Local Unity if there's the DA. So we've had all these governments since 2016, coalitions. Nobody ever called them Government of Local Unity. But now, because of this arrangement, the same government that is happening in some place where, I'm trying to find an example, let's say Eguruleni, because I want to contrast it with something else. Then people debate, and if the DA is there, then it's called the Government of Local Unity. But the same thing happens in Tshwane. There you have other parties, they debate, but they exclude the DA. It's not called the Government of Local Unity. It's called coalition government, which is correct. So again, you can't have, whether it's at the local level or the provincial level, the same thing. This one, you say it's a cat, and then this a different thing walks with 2 legs, and you say it's also a cat, and another one comes with 20 legs, a centipede, and you say it's also a cat. You must be wrong at least in one of the 3. One of those things is a cat. Okay? So that's the graphic representation of the absurdity we're talking about here, and all the various sections of the founding affidavit and the heads explain exactly that. Then the most ridiculous thing then we're told about the Mkhwebane case. I mean, what on earth? How can somebody come here and say there was a case somewhere in Kimberley, without giving you the pleadings in that case? There was a case in Kimberley where an exception succeeded. Therefore, this exception must succeed. What is that?
Well, I think the point made was that the pleading that took place in the Mkhwebane case was similar to the approach taken in this case
says who?
By the applicant.
But says who?
Well,
if it's not in front of you.
The reference to the judgment would suggest that is the case, because there was a quotation, I think, that was read to me, where Mookie J said, this is how the case was pleaded, and I found that to be insubstantial.
Yes, in that case.
In that case.
We don't know, some case about the contract or whatever Mr. Mitau said. Yeah.
Yes.
So how would you, sitting there, my lady, know that those pleadings, which you've never seen, which were criticized in some case, have got anything to do or any resemblance with the pleadings before you? You can't. if anyone wants you to make that comparison, they would have to say to you, here are these pleadings, these ones, and they are the same as these ones. Because in that case, maybe what we are being accused of was done. But here, in front of you, there is chapter and verse. I've read you all the paragraphs about explaining under the heading of legal analysis how exactly 172 is invoked, how each of those rights, and I've been talking now a long time as well, explaining the receiving of information and so on and so on.
Well,
so all of that.
Can I stop you?
Yeah.
In the affidavit, you say you're going to make the rights plain.
Yellow pages.
You're going to make them clear in argument. And you say I'm entitled to do that.
Yes.
I've said that there are these rights, and I'm entitled to put a finer point on it in argument.
Yeah.
So that is what I've been asking you to do.
Yeah.
And the point that you put is you raise the freedom of expression, that you say it manifests as a freedom to receive information rather than express information. So that's the first one. And then you say the second one is it infringes your client's right to human dignity. That is the third one. And then, the second one. And then you say the right to citizenship is also infringed.
And political rights, section 19.
And political rights.
Yes. No, but my lady, I'm afraid your ladyship is mixing two unrelated things. The thing about, we will say, argument had something to do with paragraph 74, which deals with perjury, not with those rights. Mr. Mutau made a separate point that was to do with perjury. So I can even say, give him all the thing, because I'm not relying on perjury. I don't care about that. The other point, which your ladyship is conflating with that point, had to do with paragraph 49. That has nothing to do with perjury. Okay? It's got absolutely nothing to do with I will do an argument. Even in that paragraph where we say we'll do an argument, we say we refer to section C, which is the statement of facts. So your ladyship is unfortunately conflating the two.
Well, I'm not, because if one goes to 172...
Let's assume we didn't plead perjury.
Let's move to 172.
Yeah.
172 requires that there be constitutional jurisdiction.
No.
That is what it says. Well, let's go there. Let's go there.
172 1A.
I'm just... let me just bring it up. My computer is getting a bit
I can
slow.
read it out, my lady.
Well, I've got it here.
Okay.
Yes. When deciding a constitutional matter
Within its power.
within its power.
Correct.
So that's the starting point.
Yes.
Now I must determine, is this a constitutional matter if I'm going to apply
Okay.
172?
Okay, let me...
And Mr. Mutau says, if you want to rely on 172, you've got to found the rights that you rely on in the Constitution. They can't be anywhere else. They have to be in the Constitution. And that's what I'm trying to assess.
Yes.
What the content of the right is.
Okay.
And you've told me freedom of expression. I accept that you say, I accept that you've made the argument
Yes.
that it must be turned around.
Yes.
Yes. You say the right to human dignity, and I don't quite know how your client's right to dignity is affronted by the use of
By
the GNU.
political exclusion.
No, not by the political exclusion, by the use of the term GNU.
No, but the use of the term is not in the air, my lady. The use of the term, it's like if the SABC used the term KEFA, right? The use of that term insults the dignity of those who are the viewers. So I don't understand this, that you can't then say, why are you offended by the term? No, you're offended by the fact that a state organ for which you pay, which is answerable, is using a term that symbolizes your exclusion or your denigration.
But that offensive term that you use, that directly offends against the dignity of people. And so you would be quite right that is where the right is located. It's also hate speech.
Yes.
So it's got various permutations.
It's an example, my lady.
Yes.
Let's not work with...
I don't want to split hairs. I just want to know what the content of your right is.
Let me tell you just what you've said, why it's wrong. Section 38 of the Constitution says, whether it's direct or indirect, says, anyone listed in this section has a right to approach a competent court alleging that a right of the Bill of Rights has been infringed or threatened.
Yes.
Okay?
And I want to know what right.
In other words, even if there was no actual, even if it was the most indirect way of offending a constitutional right, that is justiciable. So that's the first point. The second point is this, my lady, which again, if this doesn't answer that, nothing ever will. Forget Mr. Mutau maybe doesn't understand this, but Ms. Nomsa Chabedi, his client, does. Because this is what is said in Mr. Mutau's pleadings, signed by the CEO of the SABC, Ms. Nomsa Chabedi. Paragraph 4. The application seeks to impugn the SABC's use of the phrase government of national unity to describe the governing majority government in South Africa in its television programs. According to the applicants, this description of the government is inaccurate, and using the description violates various constitutional rights, including the right to dignity, right to equality, all the things I've been saying here are said by them. The right to freedom of security, the right to citizenship, and the right to access information by the state or another person. Okay? So they understood exactly what the case was, except until this morning. Then, what is worse, they come to this court. How can a person who says, my defense is section 16 of the Constitution, stand up here and say this case has nothing to do with the Constitution? How can that be? They say at paragraph 6, the application is without merit. The order the applicant seeks would violate the SABC's right to freedom of expression, enshrined in section 16 of the Constitution. But they say the case has nothing to do with the Constitution.
Well, what Mr. Mutau argues, and it's been argued and decided in many cases, constitutional cases, is that if you are going to evoke the Constitution, you have to plead the right.
Yes.
You can't just put it out into a vacuum. And he relies in that regard on the judgment of my brother Muki.
Yeah.
So he says you have to show the constitutional right that is being infringed.
Yeah.
And you said you would do that in argument.
Yeah.
And
no,
I understand.
I didn't, please, I did not say such a thing.
No, in the affidavit.
That's got nothing to do with
in the affidavit.
Okay. Paragraph 74. Your ladyship keeps on making.
You're locating the right.
Mistake. Okay, my lady.
You're locating the right in freedom to receive information.
No. My lady.
Human dignity and citizenship.
Where's the patch? Okay. No, in the. I'm sorry, my lady.
No. Take your time.
Yes,
take your time.
in the pleadings.
Because the fact that I locate these rights.
Yes. No. Okay. Let me
is of seminal importance.
Yes. Let me explain why your ladyship is making a fundamental mistake. I corrected it, but let me correct it now with specific reference to the pleadings. If your ladyship goes to paragraph 76.
Yes.
Okay.
Page.
749. 19-749. Thank you. Is it 2? Oh, 02-749.
Thank
you,
you.
Male. Thank you. I'm Ndeta to my learned friend. This is the part that Mr. Mta was referring to, my lady. Let's
Yes.
not confuse. It says, these legal conclusions are squarely based on the factual metrics described in Section 6. I'm advised that further elaboration will be provided during legal argument.
Yes.
Okay? That is got nothing to do, that is under the heading of PAJA. Okay?
Yes.
Actually, it's, it's called alternative relief, E2.
Yes.
Okay? In the alternative, it's PAJA and all that. So it's not what your ladyship is saying. This has nothing to do with the paragraph 49. This is about the listing of 62A, 62D, 62E, 62DG, not the rights. That's about PAJA. PAJA.
Yes, but you rely on the same factual complex.
No.
For
No,
both causes of action, if I can put it that.
Yes, but with the other one, we have explained from paragraph 55 to 73. We have gone chapter and verse as to how it is done.
Mr. Mpofu, all I'm asking for is for you to locate the right. That is all I'm asking.
Okay, but my lady...
Because in order for you, your clients, to rely on 172, there has to be a constitutional right
Yes.
that is impinged upon.
Yes.
And so your starting point is to tell me which constitutional right
Okay.
is impinged upon, and I've allowed you to do that, to
Yes,
to
and I
flesh
did.
out your case. And you've given me three things. Freedom to receive information, which you
Right.
say is a mirror image of freedom of expression. You say the right to human dignity, and because this unity is used inaccurately, you say, affronts the dignity of your clients because they are not
That's
part
right.
of the
Yes.
unified mass. I don't understand the right to citizenship. I don't understand how that is affected. And I don't understand how your right to participate politically is affected. Because somebody coins a
Parliament.
phrase that excludes you. I'm not suggesting that it doesn't exclude you. It deliberately excludes you.
Thank you.
But I want to understand how it affects
Okay.
the right to citizenship and the right to your political participation, because I am understanding political participation in the context of your right to participate as a party who has achieved a certain number of votes
Yes.
and who has the right to participate in
Yes.
Parliament.
Okay.
That's as I understand it.
Yes.
Regardless of what anybody says about you, you
Yes.
have that right.
Yes.
Yes.
Okay. I'll just have to read.
Yes.
This is what the pleadings before you say, my lady, which
Yes.
I'm sure your ladyship has read many times.
Yes.
And if your ladyship doesn't see out of this which right of where the exclusion, then there's nothing more I can do.
Yes.
So, in fact, the DA, which is specifically stipulated the exclusion, okay, and then to define an inherently exclusionary arrangement, that excludes the applicants before you,
Yes,
okay. So it's not excluding some other person. They're saying you excluded us.
Yes.
Now we are told we must tell us. Then how does that affect you? Then how does
No,
that work?
and
then
that's
say-
not how does it affect you. I understand it affects your clients.
Okay.
I want to know what constitutional right
Yes.
you are evoking.
Yes.
That's all. I
Yes,
understand
okay.
that there's an effect, there's
Okay.
cause, there's effect.
Mhm.
You need to found your case
Yeah. Okay.
on a breach of a constitutional right,
Yes,
because
okay.
otherwise you do not get to 172.
Yes. Can your ladyship please just allow me, please?
Yes, of
just-
course.
Yes. Yeah. Code paragraph 68. It says, in
Yes.
addition to the adverse impact, that also deals with the issue of the Mutau list. Yeah. Described above, the impugned conduct is also in breach of Section 7(2) of the Constitution, right?
Yes.
Which enjoins the state and its organs to respect, protect, promote, and fulfill the rights in the Bill of Rights. This is now, here's the punch.
Yes.
This has caused immeasurable harm to me as a citizen.
Yes.
I'm told you don't understand how that has happened, but let's come.
Yes.
To the second applicant as a political party which plays no role, okay, in the current arrangement for various political reasons, and to the public at large. That takes us to FOSE, which says that the violation of political rights is in any event an affront to the public at large.
Yes. I accept that.
Yes. So that's how. Then let's go somewhere else. And then we say, in relation to 16, which I've discussed here, we say
Yes.
the Section 16 does not extend to the deliberate and intentional imparting or inaccurate of information by the media, let alone the public broadcaster. We've debated this about the receiving of information.
Yes. I had
And
that
then,
argument.
and then we say advocacy of hatred that is based on race. That's a different point about which we debated this morning.
Yes.
Okay. So that's how. Second how. Third how. At paragraph 70. The so-called GNU amounts to racism in that its spirit and letter, that's the Ngobosiche point. Its spirit and letter does violence to the transformational ethos of the Constitution and the need to heal the divisions of the past. That comes from the preamble, which I spoke about this morning.
Yes.
Okay, and that's why Justice Ngobo said, if anything that offends against national unity, ipso facto is inconsistent with the Constitution. So that's the third how. And then 4, we say a second fatal mistake is this thing about the complaint and so on. Okay.
Yes.
And then yes, the other one is just and by the way, to go to the point about why you didn't attack the editorial policies. That answer is at 7.13. Says, to the extent that other remedies are also available under the complaints regime, the applicants hereby abandon those remedies and elects only to pursue the rights referred to in 7.1 above. Okay, and the party is free to do so. Justice Nugent made this clear in the case of Makanya versus University of Zululand, that you can't say to someone, if my employer stabs me or whatever, and I could invoke the disciplinary code, but I decide not to come to court and claim a civil case. You can't say, no, this is a labor matter, because you should have gone. I say, no, I don't want, I know I have those rights, but I'm abandoning them. So I'm here to invoke those rights that can be done here.
Yes.
And then we say, therefore, the court is compelled, in terms of 7, to declare the impugned conduct, which is inconsistent. And you must read this with the factual complex as well, as aforesaid. So the simple point I'm making, my lady, is that which we are accused of not having done, we have done. It's here in black and white. All right. Now, and if it was not done in some other case, in some other court, so be it. But your ladyship cannot be referred to some case. Let's say there's a case of a collusion where you didn't plead negligence in somewhere in Pretoria. And then you come here and say, well, in that case, but here negligence is pleaded. And you are told that there was a case in which negligence was not pleaded and that was upheld. Of course. Well, but what's that got to do? Unless if you can say, here was that case, here are the pleadings in that case, and here are the pleadings in this case, and on the identical facts.
Yes.
Now, to round off, my lady, there are various of these submissions, but here's the point. None of what has been said to you today by the SABC even approximately addresses the case before you, which is a simple case that says, a la class in J. And another amount of time was spent giving you the facts of the FXI case. That's completely irrelevant. it's the principle in the FXI case that is important. You can't be bound by facts. You are bound by the principles. That's what stare decisis means. That principle which came from that case was that, and this court is bound, by the way, to follow its own precedent, unless it sees that it was clearly wrong.
Or unless it's distinguishable. Yes.
Yes, but the point I'm making is that the principle that was well, it's not distinguishable for that matter, because in Classen J, when Classen J says the SABC cannot be equated with a private broadcaster which is entitled to freedom of expression, and then it says that what I read earlier, a public broadcaster may not use public money to do so. What he is saying, my lady, is not talking about the electoral code. He's talking about the Constitution. He's saying, as a matter of public policy, a private body may do ABC, but a public body, that's Constitutional Law 101.
Indeed.
A public body which is imbued with the powers of the public and belongs to the public. That's Constitution. And if that is not about the Constitution, then what is about the Constitution?
Well, it is, but you have to say how.
Yes.
It's offending
well, I've addressed
the Constitution.
That. You know, that I've
and
addressed.
that's all I've been trying to get clear. And we've gone through your list, and I have it. So we're clear on what you say offends the constitutional principles.
Yes, but my lady, no, that's not, the complaint is not, the complaint is that it is not set out in the founding affidavit, and I've just read out in ad nauseum where it is set out. So, and
you've also addressed which constitutional principles you say have been infringed.
Yes, and I do that, my lady, in the spirit of the article that I've sent by Ms. Porter.
Yes, I'm going to read it.
Yes, which says that you can, when you read section 16, it says you mustn't just look literally and say freedom of expression. It says freedom of expression is by definition part of a web of other rights which are
So you've made that submission.
Yes.
And I accept it. We've gone beyond. We've gone beyond 4 o'clock. So if you can just can you round up by answering this?
Yes.
If I find that there isn't a constitutional dispute, if I find that there is not one, do you agree that BioWatch doesn't apply?
No, of course. If there's no constitution, BioWatch by definition says that.
Yes.
But
But you say there is one, and I accept that.
No, well, so does the SABC. I just read it out where they say in paragraph 3 and 4 and 5 and 6 and 7, they say not only do they list the constitutional rights, but they say their defense is section 16. So it beats me how that cannot be a constitutional matter when both parties are saying it is.
Yes.
Yeah. So but yes,
but I have your submissions on it.
Yes. So if your ladyship says no, the SABC is wrong in its affidavit that this is a constitutional matter, and it's wrong that its defense is a constitutional defense, then of course BioWatch will not.
Thank you.
Yeah.
One last submission.
Thank you, my lady. Yes. Yes. I want to say this, my lady, in closing. You know, our constitutional dispensation, when it talks about in the preamble, it talks about this issue of unity. It says, we, the people of South Africa, united in our diversity. And it says that we want to heal divisions of the past. Well, the leadership will be surprised to find that the SABC itself, in its own editorial policy, and the leadership will find that at paragraph 50, I think 51 of the founding affidavit. It says, the mandate and objectives of the SABC encourage the development of expression that reflects South African attitude and diverse opinions in the advancement of the national and public interest, playing the role in healing divisions of the past, contextualizing the reporting without distorting facts and discriminatory reporting. And here's a big one, 5.1.6, avoiding political machinations from influencing the reporting and ensuring editorial independence. Now,
Well, that's the kicker.
yes, that's the kicker. But what I want to say, my lady, is the following. The answer, again, is in this vein that our case has not been answered. And I apologize because I stood up in this very room this morning and I said this case is not about the suppression of views.
Yes, I know.
It's not
I
about
heard you.
but Mr. Mutau went on for 20 minutes explaining that they have not suppressed the views. But I've already said it's not about that.
Yes.
So so in case, because I thought maybe your leadership would say, but Mr. Mpofu agrees with you that it has nothing to do with suppression of views. It has nothing to do with all those things that happened in the blacklisting and what have you. It has something to do with something completely different, which you must address. Not address what he says the case is not about, because it is not about that.
It's got to do, on your argument, with constitutional
Yes.
unconstitutional
Unconstitutional conduct.
conduct. And you say you've founded that conduct, and you've
Explained
done
it.
enough in your founding
Yes,
affidavit.
explained it ad nauseam.
Yes.
So it's not, I just want, because I don't want your leadership to waste time telling us that the SABC has accepted diverse views. We gave them a tick, A+ for that.
Yes.
But so it's got nothing to do with this case. It's so the mere fact that you allow people to have a debate does not entitle you to come to your example about the doctor. If the fake doctor says that I'm a doctor, and then you say, okay, I'll bring both people, those who say he's a doctor and those who are not doctor. And then in the next breath you say, well, Dr. So-and-so did that. So the mere fact that you've allowed the debate does not allow you to take sides in misinforming the public. And I promise this is the last submission, my lady. In the article, you'll find also a distinction between, and it credits current President Donald Trump for coming up with this phrase of fake news. And it says that fake news can be divided into two things. Disinformation, which is when you deliberately, that's what we accuse the SABC of doing. Or, let's assume we're wrong, then it's not intentional, then it's misinformation. And the article says both of those offend against the right to freedom of expression. And that is really all our case. Yes. That the misinformation, misdescription, whatever you call it, of the government of the day. Because if we are wrong, my lady, then it means since 1994 we've had government of national unity. Because then anything that is a government that is above 50% can be called a government of national unity. It's that absurd notion that anyone should see that it is absurd to even suggest that all the governments since 1994 have been government of national unity. We just didn't know it. It was just discovered on the 14th of June last year. I mean, that's ridiculous, with the greatest respect.
Is that a good place to stop?
That is, my lady, and as I said, we won't exercise on the subsidiarity point. We are happy with the,
You're happy
with the response.
You've
so
had the opportunity.
Well, I didn't. But
well,
I've
but
answered the issue.
you've answered the issue, even if it was on your feet.
Thank you.
Yes. Thank you, both of you. I'm going to reserve judgment. You will be informed in the usual way.
Correct.
Yes, the court will adjourn.
As a court is, we are indebted to the court.
Yes.
Always come out of national unity.
Thank you very much.